All right, the wedding you're going to, is this a forced wedding or something? You're like, yes, I want to be there.
Are we on?
Yes, so you better answer the right question. You better be like, oh no, I desperately want to be there.
I couldn't say.
Yeah. Wow. You know, some weddings that they have now, it's like a 4-day thing. I mean, whatever happened to you go get married and it's like 2 minutes.
Cheaper.
Yes. Yeah. Oh, man. Well, Daniel, if you ever get married, you're gonna have to like up and make it a 5-day event.
Oh, yeah, no, I'm gonna have to pay forward.
Yeah.
Pay it back, I guess. But I think, yeah.
Michael Villarreal.
Good morning, Your Honor.
Good morning. My mom is gonna be so happy to see you.
Probably helping out today. Right here.
Okay, so are you gonna be with us just for today or? Okay,
And maybe just for a little bit. Brittany's having some free
look
time,
at
so,
you giving like tiny presents to us.
You know, go out as much as I can.
Morning, Judge.
Good morning. Oh, Mr. De Leon,
That's fine.
that's your name.
My name. I'm here this morning on Oscar Martinez, murder, bond reduction.
Okay.
So
All right, thank you. All right, everyone, I'm gonna call the docket. So if everyone can have a seat, please. Today is Thursday. Vashon, I'm finally getting the dates right. When we're off on Friday, the dates just don't behave correctly. So today, I think, is a true Thursday and not a Wednesday in a Thursday. I'm gonna call the docket. When I call the docket, stand if you're able to, let me know you're here. If you don't answer the docket, I'm gonna assume you're not here and a warrant may be issued for your arrest. Sir, you're gonna just have to find a seat somewhere. Squeeze in like it's church. All right, John Denver. John Denver. All right, Mr. Denver, you act like you're trying to get a warrant. All right, have a seat. Have a seat. Wayne Tolliver. In custody, we have Gilbert Pruitt. Armando Mata. Armando Gabriel Mata. In custody, we have Brandon Guzman, Joe Gonzalez, Juan Garza. In custody, we have Christian Segovia, Douglas Marshall, Alfonso Diaz, Nicholas Ornelas, Destiny Argumento is in custody, Vanessa Castillo, custody, Idelulio Chewy. How do you pronounce your first name? All right, I'm gonna work on that. Julio Sanchez. Camilo Rodriguez. In custody, we have Matthew Santos. Juan Albert Casanova. Thank you. Armando Mata. Armando Mata. Jesse Raboga. How do you pronounce that last name? Rabago. He's in custody. Andy Maldonado, custody. Kevin Luna, custody. Genevieve Pinter. Thank you. And I'm going to call those who are here for compliance hearings. I know it's not till 11, but if you're here, we can take you up. Jonathan Thomas. Hillary Stillman.
Custody.
Luis Gomez. Jesus Santolo. Michael Green.
Custody.
Christopher Garza.
Here, Your Honor.
Thank you. Jesus Martinez Cantu is in custody. Oscar Martinez, custody. Wilbert Villamil, custody. Christine Garcia, custody. Thank you. Stephen Smith, custody.
Yes, Your Honor.
Christopher Caballero. Christopher Caballero. All right, is there anyone who came in late or your name was not called? Yes,
Jess Moffness,
just what?
Anthony Moffness.
Anthony.
Yes.
And what's the last name?
Moffness.
Can you spell the last name?
Mafnas.
All right, and loose the gum. All right, anyone else?
Your Honor.
Yes, what's your name?
Harvard Boston Jr.
All right, and do you know who your attorney is? Okay. Thank you, have a seat. And Mr. Moffness, do you know who your attorney is?
Ms. Linda Corey.
All right, just have a seat. Anyone else whose name was not called or you came in late? All right, everyone, these are the rules of the court. The files over here are for criminal trial division. Criminal trial division is sitting there. The files for family violence are here. Family violence prosecutors are here. I think they're going to do a name change in a minute. But those are those files. I try to keep the center of the courtroom as least congested as possible. As you can see, we have a heavy docket today. So attorneys, please listen carefully and follow these rules. Grab your file from the box, place it on either prosecutor's desk. Please have a seat. They're going to call you in the order in which they receive your file. If you have someone in custody, no matter what's happening with your case, that person who's in custody is going to need to be brought out. Once you request somebody to be brought out from custody, do not leave the courtroom, because for security reasons, the deputies are only allowed to bring out so many inmates. And if you leave and your inmate is in the box, then what will end up happening is there's another attorney who will not be able to have their person brought out. And that's a little bit selfish. And I know we're not going to be selfish today. Do not approach the court if you have not conferred with the state and conferred with your client. If your client needs an interpreter, you will need to have an interpreter called down. Once that interpreter is called down, do not leave the courtroom, because we have a limited number of interpreters. And if they are here, that means they can't be somewhere else. Once you have conferred, approach the clerk. The clerk will place the file here towards me. You will be called in the order of appearance. Please do not just stand in front of the court when your file has been placed up there. I will call you. Just have a seat. That will make things run smoothly. It will keep the court a little less congested than it already is. I want everyone to be kind to each other. Today is a great day because the rumor is tomorrow is Friday. So we have a lot to be happy about. So we're going to be kind to each other. We're going to be patient with each other. And anytime you see yourself losing patience, just reach into your pocket and pull it out. And if you see one of your colleagues losing their patience, just pull it out. Gentleman who just walked in with the shades, are those prescription glasses or are you being cool? All right. Yeah, no shades on the inside. Thank you. All right, everyone. It's going to be a great day. Please confer. Thank you. You're starting off the day correctly. How's it going? Oh, I'm doing great. I slept so well. I ended up waking up at 3 a.m. So that means that my body is like, hey, we've got enough sleep.
I woke up about 1 hour after you because I was getting on the way. Slept in my own bed till 4.
Thank you. Thank you. You know, I was concerned.
I was very concerned. Thank you.
All right. Thank you. Caroline. Oh, this is with us, but it's not with us. All right. Thank you.
Thank you. And the brewer comes.
I just took it back.
Excuse me, Your Honor.
Yeah.
Good morning.
Good morning.
The gentleman with the glasses, they are prescription glasses.
Oh, okay,
So
all right.
I said, I told him he should have spoke up.
Yeah, he should have told me.
Yeah.
Yes, so he can wear them. All right, thank you. Caroline, on this one, this should be denied. Because I think the plea. And can you have her to give me the yes, for that one too. Thank you. Oh, Caroline, before you go back, let me.
If you want to have a copy of the printed and I. I'm okay with them. I didn't have the motion yet.
Yeah, I need the docket sheets on these too. All right, thank you.
I just want to make sure. Yeah, I just want to make sure the judge.
Okay, thank you, Travis.
Yes.
Norma, did you have Denise Hairston come down?
Pardon? No, I'm not, nothing's gonna happen. Oh, are you talking to me? No, I have Stephen Smith, nothing's gonna. No, you hit the add it on for today. I just need to approach court because, he has a. Oh, yeah.
I'm not disputing you did. I'm disputing it's not on the docket.
Yeah, I was gonna see if I could turn it on as part of this. And I'll be, get signed after, I'll be ready. That's good.
I'll be back up.
I mean, that's where I'm.
Yeah.
That's why I would use.
Right.
One of them is 104, 152.
There's no difference. No, probably not. Doesn't really matter the condition.
They would bring it back to water.
I would, if you want to. We also need to. We have a position. Involved in that. Yeah. I think it has to. It's different with the section standards.
Yeah, my email address, like.
Seeing what she said.
So my email address is. Yeah, I'm not even, I just let this on my radar. And I'm trying to see what's on my radar as well.
Separate compliance. Final. Garza, yeah, Christopher Garza.
I guess you said, yeah. Oh, so you got whatever longer. Well. I know Victoria and so.
Yeah, he's on. It's a compliance. So he's on probation.
Says.
All right, who's here on Christopher Garza? Christopher Gara? All right, have you conferred with the state on this?
I confer with all of them technically.
Okay. All right, so before we go on the record, there was an issue with some sort of downloading of an app.
Yes, Judge.
I'm sorry, could everyone please whisper?
I would assume that's part of the reason that the violation report was submitted. There was an app that he needed to download by a certain deadline.
Okay, so what are we here for today? Because I don't have a violation report in the court's file.
I was told it was rejected.
I think, yes, that's you. There were.
All right, so,
If it's on the motion, I'm just giving you context for the motion, Judge.
okay.
So,
Well, I granted the extension for him to download the app, so is the app not downloaded?
and he doesn't, it said that was the problem. Probation took his cell phone. That was the reason for the need for the extension, is that he doesn't have the phone anymore to download the app. He did get a flip phone, so no flip, the flip phone doesn't have apps, but that was what the probation officer told him, either get a flip phone or download the app, and he wants his phone back, but he doesn't have it, but he wanted an extension so that he didn't get the phone, and then, oh, you're in violation, you didn't get the app. I just wanted to make sure we cover our bases. If we'd extended already, great. Once he gets his phone back from probation, he will download the app. And this motion was more of CYA.
Okay, I'm just looking online and maybe I'm wrong because I don't have a flip phone. I haven't had a flip phone in a while. But it says, who says a flip phone has to be a dumb phone? This modern day option packs key Google apps, including YouTube, Google Maps, and Google Search.
I'm not sure if this one does.
It's also equipped with Google Assistant, meaning that you can make calls, send texts, or open apps using just your voice. So does anybody know?
I'm not sure if this particular phone does. This is
Who is
pretty
your
old.
flip phone through? What carrier?
T-Mobile, man, it's a TCL.
All right, because this says download an app from the home screen, select Play Store app. So does he not have any apps in his phone?
No, Judge.
Probation. Can you have someone, I don't know if you handled it, but if you could have someone come from the sex offender unit? Yes.
And I'd be happy to provide the phone. There's no. If
So
someone
what-
could figure out how to put apps on this thing, I'd be happy to download it for them.
All right, so this is what we're gonna do. I'm gonna have someone from probation zoom in. Counsel, I'm gonna give you the Zoom link, and if you can zoom in and confer with probation who's zooming in, maybe they have some idea about the flip phone.
That's fine. And again, just our whole thing was he does want his original phone back from probation, and then he'll download the app. We just wanted more time so that he wasn't getting the phone and then saying, all right, you got the phone back, but you don't have the app. So now.
All right,
technically
so
you're in
what
violation.
you're gonna do is you're gonna talk on the Zoom link, and I'm gonna give the Zoom link to both you and Mr. Villarreal. And when they zoom in, if you will talk to them about his phone that I guess they have in custody. And then come back to the court. Because everything I'm seeing, and I'm taking your word as the officer of the court, everything that I'm seeing, that there's a way to have apps on a flip phone. So they'll zoom in, and when they zoom in, you zoom in, and I'll put you all in the breakout room.
Appreciate it, Judge.
All right, thank you.
Thank you.
Back. We're still stuck on the same place with this guy. Favorite, my favorite. Yeah, sure. You've been running marathons. That's the only one. What about Stephen Smith? Pardon me? Yeah. It said it was an add-on 2022-5003. It's NPR.
Yes.
Mr. Perez, as soon as probation zooms in, I'll put you in a breakout room with them.
Thank you, Judge.
You're welcome. For no, I'll read it. Okay, all right, thank you. All right, who is here on Stephen Smith?
I am, Your Honor.
Where's Mr. Smith?
He's in the box, Judge. Come
Yes, Mr. Smith, come
on
down.
up, sir. Come on up. I don't move inmates without your permission or the mayor's.
Oh, thank you so much. How are you doing this morning?
Well, how are you, Judge?
Oh, I'm doing great. You know, we're closer to Friday than we were yesterday. You can't beat that. So are you all ready to proceed on this motion?
No, Your Honor. I wanted to I've conferred with the state. Currently, there is a new unindicted case that has an offense date of April 23rd, 2023.
Mhm.
And the state and I are asking the court to give us a little more time for them to investigate that new case and see what is going on.
What is the new case?
ABI choking, Judge.
All right, so who's the prosecutor on Mr. Smith?
Yes, Judge.
Travis, thanks, sir.
So with regards to Mr. Smith, I'm being told that there's a new case.
That is correct, John. There was a new case awaiting indictment with an offense date of April the 23rd of this year.
Okay, and are you on that new case, counsel?
No, Judge, today was the only first day that I've heard about that new case, Your Honor.
All right, Ms. Ferguson, can you see if you can override the system and put Mr. Memori on the new case so that he can get the discovery information? All right, so you'll be on that new case. I'm going to give you a setting date. It's going to be for a contested. If it turns out it's not contested, then it won't be contested. How many witnesses are you expecting that this is a contested hearing?
Probably only one or two witnesses for the contested.
All right, Ms. Ferguson, can I have a contested date for Mr. Smith?
Judge, not the 15th or 16th, my wife.
No, two. And not the 15th or 16th. That's a May,
Yes,
council?
Judge. Yes,
Yes,
Judge.
not the 15th or 16th of May.
Please.
May 25th? All right, your contested hearing will be May 25th at 9 a.m. We will see you then.
May I be excused, Your Honor?
Yes.
Thank you for your time.
Is there a chance that your client will make bond?
Don't think so, Judge.
All right, Ms. Ferguson, can you be sure to give him a reset form just in case he makes bond? We'll see you back on May 25th.
Don't move.
Okay.
I did not make an observation one way or the other.
All right, can you make sure that Mr. Memori receives the discovery on that case, police reports, if there are any?
Yes, Your Honor.
All right, thank
I'm going
you.
to email Travis and we'll communicate on the new case.
All right, thank you.
Judge, where do you want Mr. Smith? I don't,
The deputy will take him.
okay.
Thank you.
Thank you, Judge.
Thank you.
Thank you.
Who's here on 1 Garza? Oh, Council, come forward. Thank you. How you doing today? Oh, hey, we're closer to Friday than we were yesterday. Can it get any better than that?
So much closer. Downward slope.
Well, I always tell people, once Friday happens, your weekend is basically over. So the anticipation of pre-Friday is great.
Mark, can you have a seat, please?
I think we should call this Friday Eve.
Thank you. I like that. I like it.
All right, thank you.
Douglas Marshall, your.
All right, court is calling 2023 CR 1867, State of Texas versus Juan Lyric Garza. Can I have parties announced for the record for the state?
Michael Miller, out the state.
Defense?
For the defendant.
Are you Mr. Garza? All right, you are here for sentencing. You entered a plea to attempted indecency contact with a child on March 28th. You entered a plea of guilty. The court found there was sufficient evidence to find you guilty. According to the plea bargain agreement, the state is recommending deferred adjudication. All right, have both parties had a chance to review the PSI report?
Yes, Your Honor. Yes, Your Honor.
Any objections?
No, Your Honor.
All right, state, anything you wish to say?
No, Judge, I just, we asked that you follow the plea bargain agreement. I understand that as of right now, the restitution amount is still pending as it relates to basically counseling and or medical records involving the complainant, the child complainant in the case. And so I ask that we leave that open for determination in the future if it needs to be ordered.
We're agreed with that, Your Honor. We're also agreed with the recommendations in the TAP evaluation. We're asking the court to follow the plea bargain.
Why should I follow this plea bargain agreement?
Well, Your Honor, number one, I believe my client is remorseful for what he has done. He did plead guilty to it and did plead guilty to it early on. This agreement was negotiated at arm's length with the state's attorney. There was a lot of back and forth, but I believe that the agreement that we made with the state really was in the best interest of all involved. The state was happy with it. We were happy with it. And it keeps a child victim from having to testify. I do realize that frankly, it is lenient, but it's not that lenient. My client's gonna have to deal with the consequences of being registered. He's gonna have to deal with the consequences of being on deferred adjudication. And he is gonna have a 10-year prison sentence hanging over his head in the event that he doesn't comply with every condition that you give him. I do think that he will comply. I've represented him for a little while and I've never had any problems with him. He's always been very respectful, and I think he'll be respectful to probation and to this court.
All right, state, and I'm assuming the complainant is aware of this offer?
Yes, Judge. According to the notes that I see within our system, we did talk with the mother of the child on March 29th of 2023, informed her of it, and based on the notes, she was content with the resolution and the plea bargain in this case.
All right. So, Mr. Villarreal, off the record, the probation officer is here.
Okay.
Off the record, just 1 moment. All right, I'm going to, Mr. Villarreal, if there is no further information you need to give the court, I'll excuse you to go to the breakout room
Okay, Judge.
with counsel. And I don't know if you have the updated report.
Probation did provide it to me.
All right, so if you all will go to the breakout room
Yes,
and
I'll
we'll
be
go,
back.
thank you. All right, and we're back on the record. All right, this is what the court will do. The court will sentence you to 6 years deferred adjudication as agreed to. There's to be no contact with the complainant. Chapter 62 registration. Restitution, if any, to the complainant. Proof of employment within 30 days. There's to be no employment as a home healthcare provider or with minors. Regular reporting in person or by Zoom. Regular UAs. Intensive outpatient treatment. With probation. Who do you live with?
My parents.
Are there any children in the home? All right, counsel. Why shouldn't I give him jail time as a condition?
Well, Your Honor, the reality is perhaps you should, but we're asking that you consider the items that I mentioned before and show mercy on him. My client is gainfully employed. He does earn, I believe, a little bit more than $3,000 a month. And I think, frankly, I think it's not too often that we have somebody on probation that's gainfully employed from the get-go. And I would hate for the jail time to interfere with his ability to make a living and frankly, to pay for his obligations that are going to be owed towards this court. And likely the restitution obligations that are going to be owed towards the complainant. So I do think that it is essential and it's in the best interest of the victim that he be allowed to remain out and not be taken into custody so he can work to the fullest extent possible to pay his obligations, principally the obligations to the victim in this matter. Also, Your Honor, as I said before, he did plead guilty. He did so rather quickly. He's extremely remorseful for what he's done. And I'm asking that you take that into consideration and be merciful. If the court does order jail, I'd ask that you consider him for work release or weekends only. And Your Honor.
All right, the court is going to order 30 days in the Bexar County Jail as a condition with work release, and that is to begin on May 26th. So that will give you a chance to let your employer know that you're going to be in custody. I'll put work release. Counsel, if your client decides he'd rather not do work release, but just take vacation time or whatever from work, then just let the court know and I'll change this to just 30 days.
Yes, sir.
Yes.
Your Honor, the Bexar County Jail does not do work release anymore. They're not doing it at this time.
All right, so it'll be on May 26th,
And how many days?
30 days. And counsel, you can always come back to me with regards to the work release. Maybe Bexar County Jail will change their status.
Yes, Your Honor.
Okay. And if there's an issue with the work release, then I may have him just do it on weekends, so he won't lose his employment.
Sometimes I do, but weekends are probably better. Yes.
All right.
Your Honor.
You may not want to, I don't know why people walk through that line. I mean, they're
It
just
doesn't
asking to
look-
knock things.
It doesn't look like it's that far away, but it is. Your Honor, would you consider ordering weekends right now?
No. All right. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. I'm sorry, probation. Is there anything else that he needs?
Your Honor, do you want field visits?
Oh, yes, please. Let's do field visits one time per month. until further notice. I tell you what I can do, since probation is telling me that they don't have work release, I can do 60 days GPS then, and it will be partial and it will be for work only. Would
Yes.
you? All right.
Yes.
So probation, what we'll do then, and I don't know why the jail is not doing that anymore. We will do GPS partial for work for 60 days.
And we want the 30 days.
Yes.
Mr. Garcia.
And then he'll be on the sex offender unit.
Yes, Your Honor.
All right. All right, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you.
Thank you.
You're welcome. Who is here on John Denver or Dever? Good morning. All right, just give me a moment. Excuse me, there should only be one person up here.
Oh, I'm sorry. They're the witnesses. I guess they didn't.
Yeah, that's okay.
Sorry about that.
No problem.
They got a little ahead of themselves.
That's okay. Who is the prosecutor for John Dever? It's a DWI.
Mr. Escobar, but I think it's something that.
All right, let's. All right, are you ready to proceed, State? It's
Yes,
a, it's an opposed offer.
Thank you very much.
Judge, I haven't reviewed it. Can I just have a second?
Sure, just everyone step back and we'll take that up.
The court's ready to.
All right, thank you.
Thank you. You can go back.
Yes.
Oh, sorry.
All right, so you all had a chance to speak with the probation officer?
Yes, Judge, and we came to a much easier solution. He has an appointment with probation tomorrow. They're gonna give him his,
Everyone, please whisper.
they're gonna release his smartphone back to him before he leaves that appointment. The app will be downloaded. He will start using that phone. The flip phone will go away, because no one knows how to get an app on that thing. But he will have the app on his active phone and all this.
One little misstep in there, I think he's gonna
Oh, factory reset.
reset the
Yes.
phone so that it's clear. There's no data on it that might be tempting. Then the app will be downloaded and he is not to leave the appointment until all of those things have been completed.
Yes, and that's been agreed to, and he's 100% on board with that.
Okay, so Mr. Palacios, do you need an order from the court allowing that the phone be returned to him?
That's correct, Your Honor.
Okay, I think he's saying yes.
Yeah.
So counsel, I need an order, and in that order, I wanted to state that the phone will be returned to him once it's returned to its factory settings. The flip phone is either going to be returned to the store or turned into probation. So I need all of that in the order. And we need a specific date for when that flip phone is to be returned.
Okay.
All right, so if y'all will give the court that order, then we'll proceed on that.
Okay, I'll get that phone this afternoon.
All right, thank you.
Thank you, Judge.
Have a good day, Greg.
Too. All right, thank you, Mr. Palacios.
Thank you, Your Honor.
All right, Miss Hairston. Yes.
I am inviting us in cases. I'm sending that to you. We just need to figure out to do the case resolved instead of having to come back and bring problems. Okay, thank you. Okay, thank you.
Because counsel, they're going to take him pretty quickly
To prison, yeah. So it should be done. I'm just waiting to have to sit.
Okay, Miss Ferguson, can you put a hold on the defendant?
Well, I think.
Because
Yes, they're still open.
Yeah, so that's,
they will hold him?
yeah, with those cases open.
Are you sure? Because the sheriff's departments, they've been doing some things that are not normal.
They needed dismissal too.
All right, Norman, let's just put a hold on him just in case. Because it would be very
Because
time consuming.
They might take them and then we have to bring them back with indictment.
Oh.
Yeah.
All right, who's here on Christopher Caballero?
Your Honor, the case is closed. We're just asking for property to be returned.
All right, have you talked to the state?
I have. They are in agreement except for the firearm.
Is that correct, state?
Yes, Judge.
Is your client here?
Don't believe we checked it, Your Honor. I don't think that they told him to be here. His case got dismissed. It was a PTD case, Judge.
Judge, I did notify defense counsel, which was Neil Calvis's office, whether they talked to their client or not, I don't know, but they asked me for this specific hearing for today.
That's correct, Your Honor. They did notify us.
So is your client going to be here?
She does not.
I will try to get a hold of him. Judge.
All right, thank you.
Just on a unrelated quick question.
Yeah.
A client he's in custody. He's not set today. It's a motion to adjudicate. Will the court set a bond or?
If you ask Ms. Ferguson, she'll send it to Judge Nahara.
Judge Nahara. Okay, thank you, Judge.
Who's here on Vanessa Castillo?
I am.
Are we proceeding on this motion?
I'm sorry.
Are we proceeding on this motion?
No, Judge, we're not ready. She has a pending
Counsel, you're on this side.
felony,
What is the pending felony?
failure to stop and give aid.
Are you the attorney that's on that case?
Yes, I just got appointed on it.
All right, Ms. Ferguson on Castillo, I need a reset date for contested hearing. All right, we're gonna
Okay,
come
I've got
back.
a vacation letter on file.
All right, when is your vacation?
I get back June 12th.
All right, when do you leave?
The 16th.
All right, Ms. Ferguson, counsel leaves on the 16th and she's not back to June 12th. All right, June 15th is your contested hearing.
All right. And Judge, we were going to ask for a bond on the NPR.
All right, you'll need to speak with Judge Nahara to take care of the bond matter. All right, thank you.
Thank you.
You're welcome. Who's here on?
Get it set for here.
Let me see. Oh. Done. Who's here on Mark Anthony Alvarez?
That's the one I was asking you about. So I'll go to Judge Nahara.
Okay.
Thank you, Judge.
You're welcome. Are the parties ready on John Wesley Dever? Okay, sure. Oh, they say just one moment.
Oh, I'm sorry.
Yeah, he's in the, thank you.
Who's here? Christine Marie Garcia. Where is she? Are you all ready to proceed?
Yes.
All right, come down, please. Court is calling 2022 CR 2843, State of Texas versus Christine Marie Garcia. Can our parties approach and announce for the record for the state? It is a drug case.
Is it a plea?
No, it's a.
I'm sorry, when I say, are you all ready for the motion? It's like, are you ready for the motion to revoke? So are we proceeding on the motion to revoke?
No, it's
Why not?
motion to set bond judge, the motion to revoke's not set till the 19th.
Ms. Ferguson, when is this motion set on Christine Garcia?
It was set today.
All right, it's set for a motion to revoke today. Y'all need to step back and
Sorry.
confer.
There was a motion set.
When is the MTR set?
Right now, 1 second.
Yes, copy.
May 18th.
All right, since you're here, you want to confer with the state on this motion?
Motion to revoke. Yes, Judge.
Yes, all right, so confer with the state on the motion to revoke.
Thank you.
All right, you're welcome.
Okay, well, it's hours, back in the 7 days. And we're gonna start up.
Yeah, we'll start. That's how it is with our program. We'll start. And I'll have a deputy coordination.
Thank you.
Ms. Ferguson,
Yes, ma'am.
where are they? Can you let the deputies know that they need to bring Mr. Guzman out?
Yes.
And then Robert Maurer, my understanding is getting a reset in another court if he could come back.
I know he was talking to the interpreter. We have an interpreter yet?
Okay.
Oh. He
Awesome.
hasn't talked to you yet? No.
No. For the lawyer, but he said, yeah.
And Deputy Laura, can you have Deputy Mejia bring Mr. Guzman out?
No problem. Thanks.
All right, Jeff, could I see the parties on Dever for a moment briefly? Counsel, I'm going to ask for your patience.
Oh, yeah, of
Um,
course.
We're actually going to do a sentencing on a murder case, and the state has a witness that needs to leave very quickly to testify in another case.
Yes, Judge.
So my understanding from both sides that it should not take that long.
Okay, anything the court needs.
All right, thank you so much. I appreciate it.
Maybe run some errands and. get
Yes,
back to you in
yes,
20 minutes.
yes.
Thank you.
All right, thank you.
Yeah, I mean. You guys.
Okay.
Hearing.
All right, is there anyone else who's ready on a brief matter before we take up sentencing on this case? Mr. DeLeon, you ready? Okay, which case do you have? All right, could I see the file on Oscar Martinez?
He's in custody.
Okay,
He's on the recall, Judge.
okay. All right, thank you. All right, who is the state on Oscar Martinez? It's unauthorized use, evading. Ah, I call your name 3 times and you appear in my mind. All right, so let's start with discovery issues. Which case is there a discovery issue?
Judge, we're here on the murder charge,
Okay,
not the UN.
all right. So is there a discovery issue on the murder case?
I think we're coming back on Monday for discovery, actually.
So you just here for a bond today?
We're here for a bond reduction.
All right, and normally we're sending cases for bond to Judge Nahara, but I know this was specifically set in this court for this day. So state, are you prepared to proceed on the motion for the bond? Okay. All right, court is calling 2022 CR 4932B, State of Texas versus Oscar Martinez. That party is announced for the record for the state,
Jason Gearhand, Your Honor.
for the defense.
Michael DeLeon for the state, Your Honor.
And are you Mr. Martinez?
Yes, sir. Nice to meet you.
All right, off the record for a moment. Counsel? Counsel? We're on the record, so if you want to speak to your, that's okay. If you want to speak to your client, they'll have to be moved to that end. But I can't have people speaking behind the court reporter. All right, we're back on the record. Defense, you filed a motion to reduce bond?
Yes, Your Honor. Mr. Martinez bond, he's been currently locked up for the past year in Bexar County Jail. Bond's currently set at 200,000. He's charged with murder, essentially as a party, Your Honor. What we're going to be asking for to get to the very end is that we're going to ask for a reduction down to 80,000. The court knows that the purpose of a bond reduction, a bond, is to secure the defendant's appearance in court. Mr. Martinez here is 20 years old. This happened when he was 19. Essentially, Your Honor, to give you a brief synopsis, he along with 4 juveniles were in an SUV. Apparently, the evidence shows that there was an attempt to rob a drug dealer of drugs, money, or both. Okay. During that incident, apparently there was a shootout between a juvenile who was in the SUV with my client and the unknown drug dealer. Okay. Because of that, there were two deceased people. One, the juvenile who got out to confront the drug dealer, and a complete innocent bystander who was in his home, and a bullet went through that shootout to the neighbor's home, and a citizen was killed. Okay. I'll briefly say that at no time in looking at the evidence There's no evidence that my client ever possessed a gun, had shot a gun. Any witnesses to show that he was part of this beyond being part of at most a robbery attempt, okay? For Mr. Martinez, he does have a job if he gets out, Your Honor. He does have a mother and a father, stable home life. He will live with his parents. He has a job as a foundation repair with Baird Foundation, BAIRD. He's been doing that work for about almost 2 years. If he gets out on bond, he'll be appropriately going to that work. We believe GPS would be completely appropriate in this type of case. I've talked to Mr. Martinez. If you drug test him today, Your Honor, he's going to come out clean.
Hope so.
You would imagine so, but he will come out clean, Your Honor. He's done no drugs while in jail. Any type of curfew, any type of conditions the court wants to impose on him, we believe that an $80,000 bond will be sufficient to return him back to court and address these charges in a timely manner. He has been locked up for over a year. And I believe that an $80,000 bond is sufficient to return him back to court and to face the charges, whatever those charges might be down the road.
Great.
Well, Judge, I almost concur with everything that Mr. Zollion mentioned, but however, one of the major things that may be missing is that this is just short of a capital murder. Because like Mr. Dillion mentioned, they were at a drug deal possibly and trying to, in a sense, steal, rob, or aggravatedly rob a individual that they did have a shootout with, and both sides were shooting at each other. And during that course of that, one of the defendants, co-defendants, was killed, and then another person across the street was killed. But the fact remains is that a $200,000 bond upon something like a capital murder is very, very appropriate, if not low. And for a murder of this type, Your Honor, I believe that $200,000 is an appropriate bond amount. Plus, even after this murder, he picked up additional felony cases of a UUMB and a misdemeanor case, Your Honor. So, and the community safety standards, I believe that $200,000 is appropriate.
All right, Mr. DeLeon, it's your motion, so I'll give you last argument.
I agree with almost everything Mr. Garahan said, Your Honor, as well, because this would be appropriate, but factually, looking at this specific defendant, the evidence is not going to be there, I believe, for the state to show that he was more than just a party to a robbery, and the state doesn't have the alleged gunman who was being robbed. The last thing I would say, Your Honor, is just in case, hypothetically, we thought that Mr. Martinez was shooting a gun factually, and it'll take 10 minutes to go through all that, but I will just sum it up. Factually, if Mr. Martinez was firing a gun, there's no evidence that he would be shooting in the complete opposite direction of the innocent citizen who was shot, and his associate juvenile who was killed. He was shot in the face. Factually, it would make no sense for the defendant to have shot his juvenile friend in the face, because the juvenile should have been completely facing the opposite direction. So just factually, there is no evidence that's going to show that my client had a gun, shot a gun, and even if he did, he wouldn't have caused these two deaths.
Okay. All right, and I do show that this is set for discovery as well. So I'm going to give you all, after I make my ruling, I'm going to give you all one more discovery setting. And then the state will be required to tender an offer. So I'm going to reset this for 45 days. Ms. Ferguson, can I have a 45-day reset?
Yes,
And this is going to be for discovery, and state at that time you'll need to make an offer.
Yes, Judge.
June 22nd.
All right, so we're going to come back on June 22nd. Mr. Martinez, your counsel made an excellent argument for why your bond should be reduced, but I have to look at everything in totality. I am going to deny the motion for the bond reduction. I'm going to order full GPS, and I'll waive the GPS fees. And we'll see you back on June 22nd, okay? All right, thank you.
Thank you, Your Honor.
Thank you. Are we ready on Mr. Guzman? And Mr. Guzman, is an interpreter needed on Guzman or no?
It should not be needed.
That's for his other client. He
All
has
right.
two clients here today, one's Spanish speaker and the other one's not.
Okay, so we'll take up the interpreter case first, which should be very quick, and then we'll take up Mr. Guzman.
I don't see Mr. Mellon.
He left.
Let me
I
check.
think he's in the hallway.
People down.
And state on Mr. Mauer's other client, Jesus Martinez Cantu, has an offer been tendered? Oh. Mr. Mauer? We need to take up your case involving the interpreter.
Yes, the state has, we were here on a phone dump, Judge. The state has the phone dump. I'm gonna bring my, I have an external hard drive I'm gonna bring tomorrow morning. So they can download it for me.
All right, just a moment. Mr. Martinez Cantu, and could I see the interpreter?
No.
All right, so on Jesus Martinez Cantu, what's due today is the acknowledgement of discovery. And the state, you need to have tendered an offer to the defense. So did you tender an offer?
Not yet, Your Honor. The state has obtained the outstanding discovery, and I believe defense was wanting to receive that before we made an offer.
I wanted to look at that, Judge, before I thought about pursuing an offer.
So all discovery will be received once you provide him with the hard drive or whatever you need.
I'm gonna bring it tomorrow and it's like 16, whatever.
It's the discovery itself is over 30 gigabytes, so that's why an external hard drive is needed to provide it.
And I've got one that'll work, so I'll bring it over tomorrow.
All right, Ms. Ferguson, can we recall this case for 30 days?
Yes, ma'am. I can do June 1st.
All right, we're gonna come back on June 1st. State on June 1st, you need to provide a plea offer to the defense. And the acknowledgement of discovery will be due.
I'll be ready for my other case in about 5 minutes.
All right, thank you.
Thank
Is
you.
there anything else?
No, Judge, that's it.
All right, do you have any questions, Mr. Martinez?
No. No.
All right, thank you. Thank you so much for coming.
Thank you.
What case? Yes. Well, talk to Michael and see if he wants to counsel.
Okay.
All right, who's here on Marshall Douglas Marshall?
William Davidson for Douglas Marshall to NPR.
Your client's still in federal custody or has he been released?
He's in state custody, but he's waiting to go to federal custody.
All right, are you ready to proceed?
Yes, Your
All right, could I have Mr. Douglas come down, please? Court is calling 2019 CR 9207W State of Texas versus Douglas Marshall. Can I have parties announced for the record for the state
Lindsay Shaw for the state.
defense?
William Davidson.
And are you Mr. Marshall?
Yes, ma'am.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Douglas Marshall who was placed on community supervision in 2019 CR 9207W for the offense of evading arrest detention with the vehicle on August 21st, 2019 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Violated condition number 5. In Bexar County, Texas, the defendant Douglas Marshall did then and there fail to report to the supervision officer as directed for the months of January, April, and May 2022 in violation of condition number 5.
How do you plead to that? True or not true?
We'll waive all the remaining violations.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation condition number 5, the court could find it true, grant the motion, sentence you up to 2 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation condition number 2?
Yes, ma'am.
Court will find, violation of condition number 5.
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Your Honor, the agreement is that this court grant the state's motion and sentence the defendant to 2 years TDC.
Is that the agreement?
Yeah, yes, we are asking for back time though, because he has more than 2 years and he'll be transferred into federal custody.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
Counsel, I need a trial court certification of defendant's
I
rights.
have it, Your Honor. I'm
Oh, thank
sorry.
you.
Got it signed. I just didn't turn it on.
All right, the court will follow your agreement. Grant the motion, sentence you to 2 years in the prison. There's a $1,500 fine, time and money to run concurrent, give you credit for any time served. I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Good luck to you. You're gonna have to make decisions in your life.
That's a question.
Yes, you can.
So how many days am I getting back time? Credited?
You'll receive credit for any time that you were in custody on this case. So when you were arrested for this case, you will receive credit for that. When the motion, when the motion to revoke was issued and a warrant was issued and you were in custody, you'll receive credit for that time. And you'll receive credit for that time if the motion was active and you were in federal custody. You understand?
Because when you had sentenced me my 4 years probation, I never got released. I went to TDC for 2 years back on my parole violation. And then I did a year in the world and now I've been incarcerated now for a year, which makes 3 years.
All right, they'll check that. You have the
I only
dates?
have the bear.
All right, so counsel, if you can give her the dates for him in federal custody and in state prison, we'll take care of that.
All right.
And once I receive those dates, if it's a judgment satisfied, I'll put in the judgment that is a judgment satisfied. But they'll still want to calculate your time.
Okay, thank
All right, do better with your life.
you.
I said, do better with your life.
Thank you.
All right.
Uh,
Robert, are you ready on your case?
Yeah, they're bringing them out right now.
Okay.
Are we doing it, up here? Or-
How many witnesses do y'all have?
I have 3.
State, how many witnesses do you have?
2 or 3. Are they lengthy witnesses? I'll tell you. I know.
Deputy Laura, it may be easier for you all if it's done at the table instead of up here.
We already have the video.
All right, thank you.
Judge,
Yes. Can you mute us that one?
Judge, can I approach for a moment?
Yes.
Judge, you had Alice come back and the motion can change it in a contract order,
Mhm.
but I understand you guys are considering.
Yeah, it's, so if you can come back, I would say, if you can, come back at about, they're telling me it should take very short, so 11 if you can.
Oh, you think we'll get it first?
Oh, yeah.
Okay, perfect.
Deputy Laura? We need to set up the camera.
I'm sorry? You want to call for?
Well, they're entitled to.
It's a sentencing hearing.
Whenever they do. So this is, anyway, just reassigned.
So everyone, excuse me, could I have everyone's attention? So we're going to do sentencing on a murder case. I realize that sometimes cases, people are very emotional, but that is not going to happen in this courtroom. If there is any outburst from anyone, you will be escorted not only from this courtroom, but from the courthouse. There is to be no video, cell phone taking in this courtroom by any parties in the gallery. Does everyone understand? If people cannot follow those rules, you will be escorted out of the courthouse in this courtroom. All right, the court is going to call 2019 CR 10921, State of Texas versus Brandon Guzman. Could I have parties announced for the record for the state?
Jason Garahan and Daniel Escobar, Your Honor.
Defense,
Robert Mauer for defendant.
are you Mr. Guzman?
Yes, ma'am.
All right, the defendant went to jury trial on the charge of murder. He entered a plea of not guilty, and he was found guilty by jury. We're here for sentencing today. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes.
Any objections to the PSI report? State?
Not from the state, Your Honor.
Defense?
No.
State, any witnesses for punishment?
Yes, Your Honor.
All right, state, call your first witness. If neither party has any opening statements, we'll proceed with testimony.
We'll waive our opening statement. I waive opening, Judge.
All right, state, call your first witness.
The state called Detective Raul Juarez.
I can't hear you. The microphone. Thank you.
All right, if you take a seat here, please.
Yes, ma'am.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record, please.
Raul Juarez.
And if you could spell your last name.
Juarez.
State.
He doesn't have a Zoom microphone.
This one?
The extra one?
No. Thank you. And Judge, at this time, the state would like to reoffer all evidence that was produced during the guilt and innocence phase of this trial.
Any objection?
Just based upon my previous objections and the court's rulings.
All right, so noted, it's admitted.
Thank you, Your Honor.
All right,
Yep.
state.
Thank you. Detective Juarez, obviously you testified here before during the guilt innocence phase, and you're aware that the defendant in this case was found guilty of murder. Is that correct?
Yes, sir.
And you are the assigned detective on this case. Is that correct?
Yes, sir.
And that SAPD number, is that 1916-0828?
That's correct. Yes, sir.
And let me just, I'll try to be as brief as possible, but how did you develop this defendant that was convicted in this case as the suspect in this current murder?
So the survivor, initially we have a nickname from the surviving victim, Mark Hernandez, went back to the office and consulting with another detective. They were working an aggravated assault at 527 South Acme Road under 19-133818 that occurred on June 23rd. At that scene, Miranda Garcia had left her ID card. And so I looked up Miranda Garcia, and on her Facebook was what linked Mr. Guzman to that case, which linked it to the murder that I was investigating.
And you rattle off some numbers there. Was that an SAPD number that you just stated?
Yes, sir.
At 19-13-3818?
That's correct, sir.
Okay. And you stated that aggravated assault had happened on June 23rd, 2019.
That's correct.
And in previous testimony and previous evidence that was entered, I believe in the guilt innocence phase, that the Facebook page actually was entered into evidence. Is that correct, of Miranda Garcia?
That's correct, sir.
And that's how you got the name Guzman and then also Brandon, and hence the name Brandon Guzman.
That's correct, sir.
And that's the suspect and also the individual that was convicted in this current murder charge.
That's correct, sir.
And at that scene of the aggravated assault, were there any 45 shell casings found at that scene?
There were
Judge, I'm
two-
going to object to hearsay.
Your Honor, this is a course of investigation.
Judge, it's still hearsay. Even unless he conducted an investigation himself, it's hearsay.
All right, the objection will be overruled.
Thank you, Judge. You can answer the question.
There were two 45 caliber shell casings at that scene, sir.
And did you get those shell casings sent to the Bear County lab to be analyzed?
Yes, sir.
And was obviously in that case, was a suspect developed in that case?
That's correct, sir.
And who was the suspect in that case?
Brandon Guzman.
Thank you. Were there other cases associated with this case?
So we received a NIBIN lead report, which listed other cases that were linked to the
Judge, I'm going to
245.
object to hearsay again.
All right, that'll be sustained.
Let me ask you, was there this suspect that you worked on, this individual, Brandon Guzman, did you develop him as a suspect in any other cases?
Judge, I'm going to object to hearsay again. It's just, all he's doing is backdooring the same question he just asked.
All
Your
right,
Honor,
that'll be overruled.
Thank you. You can answer the questions.
Mr. Guzman was also a suspect in an aggravated assault.
Any other cases?
And he came up because of the shell casings in a unsolved murder.
And so tell me, you said on an aggravated assault, what case number was that?
That was 19-11-0956.
And what date did that happen on?
That occurred on May 26th, 2019 at about 12:30 in the morning.
And was there a listed victim on that case?
Yes, it was Mr. Herschel Davis.
And were there shell casings, 45 caliber shell casings found at that scene?
There was one 45 caliber shell casing.
And did you have that shell casing sent to the lab to be analyzed?
Yes, sir.
And then this other case that you mentioned that happened, what date did that other case that you mentioned happen?
The murder happened the same day, about 2 hours after this, on May 26th, 2019.
You said roughly 2 hours after?
After the ag assault. Yes, sir.
What SAPD case number is associated with that case?
19-11-0993.
Was there a victim named in that case?
Yes.
Who was that?
Delvin Scott.
And were there 45 shell casings found at that scene?
Yes, sir.
And were those sent to the lab by you
Yes, sir.
to be analyzed?
That's correct.
We'll pass the witness, Your Honor.
Defense.
Other than the shell casings, what other evidence do you have on these other cases implicating Brandon Guzman?
So you're correct. I didn't handle the other cases, but on the ag assault, he was identified on the one with the Herschel Davis as a victim. He was identified in a photo lineup, sir.
By?
By
who?
the victim,
Okay, what's the victim's name?
Herschel Davis.
Where is he? Did you conduct the investigation?
No, sir. I didn't conduct that investigation.
So you have no personal knowledge.
No, sir.
So let's talk about, you said on one of the ag assaults, they found an ID for a girl named Miranda, right?
Miranda Garcia. Yes, sir.
Okay. And what was Miranda Garcia's relationship to Brandon Guzman?
It was stated as a boyfriend-girlfriend relationship.
Okay. Are you aware she is presently incarcerated on her own murder charge?
Yes, yes, sir.
Okay. So you have no way of knowing whether or not Miranda was the shooter in these cases as opposed to Brandon Guzman, correct?
So I didn't handle the investigation, sir, but the victim identified Mr. Guzman as a shooter in that ag assault. The one if
Did you conduct a photo array?
no, sir.
Okay. Who did?
I would imagine it was Detective Dillon who was the lead in that case, sir.
Okay. Do you have the report with you on that other ag assault?
I have her prosecution guide.
Okay, so does it talk about whether or not there was a photo array done or photo lineup? Or what manner the identification was made?
So it was made by the victim, calling the community engagement civilian that works in the office and stating that they found him on Facebook and then that she had,
Who found him on Facebook?
the victim.
The victim found him on Facebook?
Yes,
Who is this community engagement person you're talking about?
that would be William Miles, according to the report.
Okay, so there was no photo array done.
I'm looking at the report. No, sir.
Okay. And so you don't have, I guess, you have no personal knowledge. You're just reading off somebody else's report, correct?
That's correct, sir.
And on the case where they found Miranda's ID, did you question Miranda about how her ID ended up at this place?
No, sir.
And there was no gun ever found, correct?
No, sir. No gun was recovered.
So you say on one of the cases, you have somebody identified Mr. Guzman from social media, but on the other case, all you have is a shell casing, right?
Yes, sir.
Okay. And the DA asked you about that shell casing being sent off, right?
Yes, sir.
But there wasn't a match on that one, correct?
On the,
The second one? The one where you found a single shell casing?
you're talking about the Hamptondale
Mhm.
one.
Yeah.
They all match, sir.
You sure?
Yes, sir.
You positive?
According to the lab reports, yes, sir.
Okay. But you have no way of knowing who fired that weapon, correct?
So Mr. Guzman was developed as a suspect.
I understand. No.
No,
I understand.
yeah,
I
yes,
understand.
yes, sir.
You said that already,
Yes, sir.
but developed as a suspect and the person who actually did it doesn't mean necessarily the same thing, correct? Are there any eyewitnesses, any testimony, any statements from anybody?
On the Hamptondale one, like I said, he was identified in a lineup, sir. That's all I know of.
Okay.
As a person who did
Okay, hold
the,
on. So which one was the lineup and which one was the social media deal?
so the lineup one was the one on Hamptondale, the same night as the murder. The social media one was the month before the murder, he was found guilty on.
Okay, so let's talk about, it's Hampton Dell, right?
Yes, sir.
Who, well, I guess, I mean, you didn't conduct it personally, right? So you don't really know.
No, sir.
You're just testifying from somebody else's report.
Yes,
correct?
sir.
Do you have the report there in front of you? Or you said you have the prosecution guide, right?
I have the prosecution guide for both of them, sir.
Okay. So who conducted the photo array for the Hampton Dell one?
For the Hamptondale one, I did, sir.
Okay, so that's your report?
No, sir.
You just assisted in the investigation?
Yeah, just with a photo eraser.
Okay, so what made you, so this was the same night as the murder that we're here on? The Hampton Dell case?
No, sir. It's a separate unsolved murder that same night, 2 hours after the Hamptondale one, sir.
Okay, hold on. So you have Hampton Dell, that's the ag assault, right?
Yes, sir.
Okay. And then you said there's a separate, what, a murder case?
Yes, sir. On Chase Hill, 15651 Chase Hill.
Okay. And you said was there a casing or something found there?
Yes, there was 3 shell casings found.
Okay.
40.
Any eyewitnesses, any other testimony?
No, sir. That one's an open one. Nobody's been identified in that one.
And then on the Hampton Dell, on the ag assault, what, that was later on, that was afterwards? What was that?
That was the Hamptondale was approximately 2 hours before the murder on Chase Hill, sir.
And did you bring the photo array with you?
Detective Aguilar he was the lead on it. He had the photo array. I just showed it.
Who assembled the photo array?
I believe I did. Yes, sir.
Okay. And what made you include Brandon Guzman in the photo array?
Because of the shell casing matches off the Nibin lead, sir.
Okay. How long after the shooting on the case in Hampton Dell did you conduct the photo lineup?
Oh. It was in August,
Of
August 13th of 2019.
I pass the witness.
State.
I just want to clarify. The ag assault that happened on Hampton Vale, and tell me if I'm correct, it happened on May 26, 2019.
Yes, sir.
And then roughly 2 hours later on that same night, or early morning hours, the other end of the case of a unsolved murder happened on May 26, 2019.
Yes, sir.
And then on June 23rd, 2019, that's where you have an aggravated assault where Miranda Garcia's ID was found there, and that led you to a Facebook page. Is that correct?
Yes, sir.
And then the murder that we're currently here for today happened on July 29, 2019.
Yes, sir.
Okay. And I believe that defense counsel asked you about the shell casings matching up or not matching up.
Yes, sir.
You stated all those shell casings matched up.
Yes, sir.
Thank you. No further questions, Your Honor.
I have nothing further.
All right, is this witness excused?
Please, Your Honor.
I don't need him.
All right, thank you. State, call your next witness.
The state calls David Pendleton. And Your Honor, just to let the court be aware, defense counsel be aware, Mr. Pendleton is under the weather, so he's maybe a little groggy. Just
All right, thank you. If you raise your right hand for me, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can take a seat. If you'll keep your voice up so the court reporter can hear. If you'll state your name and spell it for the record, please.
My name is David Pendleton. That's Pendleton.
Right, state.
Thank you, Your Honor. May I proceed?
Yes.
Thank you. Mr. Pendleton, we've obviously gone over all your credentials. Everything that's come in to the case during the guilt innocence phase is offered at this time. So we won't go over all your credentials and your experience. I'm going to jump right in and why you're here today. On a case number, SAPD case number 1916-0828, did you perform a firearms report or write a firearms report on September 10th, 2019?
Yes, I did.
And is that associated with some complainants that are listed on your report?
Yes.
And who are those complainants?
Mark Hernandez and Justin Laravee.
And are there suspects listed?
Brandon Guzman.
And what did you test on that particular firearms report?
3 fired 45 auto caliber cartridge cases.
And you testified at the guilt innocence phase of this trial that these 3 cartridge cases, spent cartridge casings, all were fired from the same weapon. Is that correct?
Yes, sir.
Thank you. Can we move to another firearms report that's listed as July 1st, 2021? Do you have a report there in front of you that has an SAPD number of 1911-0993?
Yes, sir.
And does it have a listed complainant listed on your report?
Complainant is Delvin Scott,
And does it have a listed suspect?
Brandon Guzman.
And associated with this report, did you test any cartridge cases on that case?
Yes, also 345 auto caliber cartridge cases.
And with those 3 fired cartridge cases, were those all fired from the same weapon?
Yes, they were.
Were those also compared to other case numbers, SAPD case numbers?
Yes.
And what other case numbers were they compared to?
SAPD case number 191-60828 and 191-33818.
And when you compared all those shell casings together, did you determine whether they were fired from the same weapon?
Yes, sir.
And were they fired from the same weapon?
Yes, sir.
Thank you. Onward to the next report that was listed as July 1st, 2021. Do you have a report that's listed SAPD number 19133818?
Yes, sir.
And were these also 45 shell casings that you were tested in that case?
Yes, sir. A total of 2.
And did you also compare those to SAPD case numbers 1911-0993 and also SAPD number 1916-0828?
Yes, sir.
And did you determine whether those were fired from the same weapon?
Yes, sir.
And were they?
Yes, sir.
Thank you. Can we move on to firearms report, July 1st, 2021? Do you have a case number in front of you of the SAPD case number of 1916-0828?
Yes, sir.
And do you have a listed complainant in that case?
Again, Justin Laura V.
And do you have a listed suspect?
Brandon Guzman.
And in this particular one, were these 3 of the 45 auto caliber cartridge cases that you tested, were those previously tested and were those compared to other SAPD numbers?
Yes, sir.
And were they compared to SAPD numbers 1911-0993
Yes, sir.
and also to 1913-3818?
Yes, sir.
And were those determined to be whether they were fired from the same weapon?
Yes, sir. They were.
And were they fired from the same weapons?
Yes.
Thank you. Moving on to firearms report, January 4th, 2023. Do you have an SAPD number on this report listed at 1911-0956?
Yes.
And in this case, it looks like there was also a 1 unfired 380 auto caliber cartridge case. Is that correct?
Yes, sir.
But also submitted in that same report, was there a 1 fired 45 caliber auto caliber cartridge case?
Yes.
And was that 45 caliber cartridge case that was spent, was it tested and compared to other SAPD numbers?
Yes.
And was it compared to 1916-0828?
Yes.
And also was it compared to 1913-3818?
Yes.
And did that 45 spent serial casing match those other ones that were in those other cases?
Yes.
And were they fired from the same weapon?
Yes.
On move to January 4th, 2023. Do you have an SAPD number associated with 1913-3818?
Yes.
And in that particular case, you've tested 2 cartridge cases in that were previously tested. Were those cartridge cases compared to another SAPD case number?
Yes, they were.
And were those compared to SAPD case number 1911-0956?
Yes.
And did you determine whether those were fired from the same weapon?
Yes.
And were they fired from the same weapon?
Yes.
Thank you. And then another January 4th, 2023, case number, SAPD case number 1916-0828. Again, these are the 3 spent 45 auto caliber cartridge cases that you tested previously. Were those compared to an SAPD number?
Yes.
And is that SAPD number 1911-0956?
Yes.
And were those determined to be fired in the same weapon?
Yes.
Thank you. We'll pass the witness, Your Honor.
All
No
right.
questions.
All right, is this witness excused?
I don't need them.
Release, please.
All right, thank you.
Thank you, Your Honor.
State, call your next witness.
At this time, the state rests, Your Honor.
All right, defense, do you have any witnesses?
I do, Judge.
I'll call your first witness.
I'd like to call Crystal Gonzalez.
Crystal Gonzalez. All right, if you'll take a seat here, please. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can take a seat. Make sure you speak up so the court
Yes,
reporter can hear. And if you'll state your name for the record and spell it, please.
My name is Crystal Gonzalez. My name is spelled Crystal. Gonzalez, Gonzales.
All right, yes.
Crystal, how are you related to Brandon Guzman?
I'm his cousin.
Okay, and you understand we're here today because he was found guilty on this murder charge, and it's time for the judge to assess punishment.
Yes, sir.
Okay, and so you and I talked earlier about Brandon, and can you tell me about or tell the judge about Brandon's childhood?
He lived a very hard childhood. I can relate to that because I did too. And Brandon's such a good kid. It's just he was raised wrong. I raised him. He was raised by my grandmother. She got sick. She passed away. And so he was adopted. He was in foster care and he got adopted by a family member. So, you know, his mother was never there for him growing up.
Okay, and I believe you said he had been in and out of foster care.
Right.
Correct. And there were issues in his childhood that that you thought caused some emotional issues, correct?
Yes.
Can you tell the judge about that?
Well, we were all molested by our grandfather, and I was too. And I feel like we never got the help we needed, and he didn't either. And he looked up to my grandma so much, the one that raised her, and she passed away, and she was no longer here to be there for him. And he just went, you know, he made wrong decisions and went the wrong path. Thankfully, I didn't, because I had like my kids to look up to. But
so what are you asking the judge to consider? I mean, obviously, he's been found guilty of this charge.
I know that we all pay for what we do, but I just ask that you give him a lighter sentence due to his past and him having he was lost. He doesn't have his mother. She gave him up. She's still not even around to be there right now that he's incarcerated. I mean, I was there for so long, but I ended up having my kids, and I mean, I could be there for him. And it was just his childhood, and he didn't have any guidance at the time, and he was lost, hanging around with the wrong people. And I just ask that I know that he has to pay for what he did, but if you can find it in your heart, and I know God, he will have his judgment day, and he would have to pay, and he would only have to answer to him. But I ask that you just give him a light sentence.
All right. Thank you, Crystal. I pass the witness.
State?
And proceed, Your Honor.
Yes.
Thank you. Ms. Gonzalez, sorry. What's your date of birth, ma'am?
My date of birth is September 23rd, 1988.
September 23rd,
1988.
88. Okay, ma'am. And so you're cousins to Mr. Guzman, is that correct?
Yes.
And so were y'all raised together?
We were raised together. My grandmother raised both of us.
And let me ask you, when did your grandmother pass away? How old were you, rather?
I was, oh my God, I don't remember.
You don't remember, but you're not much older than your cousin, are you? He's 27 years old right now.
I am 34.
You're 34? Okay. And have you murdered anybody?
No,
Okay. How many children do you have?
I have 5.
5 children. And let me ask you, you want them to have somebody to look up to, is that right?
Right.
And is this person that was just convicted of murder a person that you think that would be a good person to look up to?
No.
Okay, thank you. No further questions, Your Honor.
No, nothing further.
All right, thank you so much. Defense, call your next witness.
Judge, I'll call Safa Guzman.
All right, Safa Guzman. Can you raise your right hand? Do you swear testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. And if you could state your name and spell it for the record, please.
Hi, my name is Safa Guzman, SAFFAH GUZMAN.
You may proceed.
Okay, Safa, I'm gonna have to ask you to speak a little louder, okay? Try to lean into the microphone. Can you tell the court your relationship to Brandon?
I am his sister.
Okay, and we heard Crystal talk about Brandon's childhood, and I assume you were in the same situation, correct?
Yes, sir.
Is Brandon older than you?
Yes, sir.
And I guess Crystal talked about the situation in the in y'all's childhood involving your grandfather. Do you believe that had an effect on Brandon's behavior and how he acted later on in life?
Of course it did.
Did you or any of your family ever get counseling?
No.
And I assume no criminal charges were ever filed.
No.
And the grandfather in question is now deceased, correct?
Yes, sir.
And after y'all's grandmother died, were y'all eventually adopted by an aunt?
Yes.
Okay. But y'all have had no contact with your birth mother.
We did every now and then.
Okay. But not for a long time, or it was intermittent?
We couldn't. She was hard to handle.
Okay. We talked about Brandon, and when you talked to me about Brandon as a brother and the Brandon you saw. Did you ever notice a time when you thought Brandon's behavior began to change, and that you were concerned that he was maybe hanging with the wrong people or running with the wrong crowd?
Yes.
Did you ever try to talk to him about that?
No.
But you're younger by what you said, 4 years, is that correct?
5 years apart.
5 years apart. And what would you like to ask the judge to consider in regard to his sentence? You understand he was convicted, and all we're here for today is the judge to determine what his sentence is.
I understand what his sentence is. I would just ask to be reduced. He has a child to attend to. He has a family that loves him. We miss him. He's done 4 years, like 99 years, really too much.
Okay, so you're just asking the judge to take into consideration his childhood and the problems he had in assessing whatever sentence she gives him?
If she would, please.
Okay, I pass the witness.
All right, State.
Thank you, Your Honor. Actually, I think I misstated the defendant's age earlier, so I'd like to correct that. How old are you, ma'am?
I'm 18.
18, and do you know how old your brother is?
23.
23, thank you. I stated earlier 27, so that was incorrect. I want to correct that. I have one question for you. If a family member of yours was shot in the face, how many years would you like that person that shot them in the face to get?
Not a lifetime.
Not a lifetime? What would you like them to get?
5 to 30 years. 5 to 30 years,
5 to what?
30 years.
5 to 30 years if somebody shot your family member in the face. Okay. No further questions, Your Honor.
Nothing further.
All right, you may be excused. Defense, call your next witness.
I'd like to call Felicity Soto.
All right, Felicity Soto. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth to help you out?
I do.
All right, you can lower your hand, state your name for the record. Please keep your voice up and spell it. So,
Felicity Soto, FELICITY, and then SOTO.
right,
May I proceed?
defense, yes.
Felicity, could you please lean into the microphone so we can?
Yes,
Felicity, tell us how you related to Brandon.
I'm his cousin.
Okay, and we've heard testimony from Crystal and Safa about their experiences as children. Were you raised in the same house with them?
Yes, we all were.
And I take it you suffered the same situation they did in regard to your grandfather?
That is correct.
Did I take it, have you ever sought counseling or talked to anybody about what
No.
happened?
We didn't get help.
Okay. Did you get placed in foster care with Brandon and his sister, or were you in a different?
No, I had my mother.
Okay. Did you ever notice a change? I'm sorry, what's your age?
I'm 24.
So did you ever notice a change in Brandon's behavior? I guess throughout all his experiences in foster care and then finally getting adopted.
Yes, we did.
And what did you notice?
He was just, whenever my grandma had passed, he changed a lot. He was with the wrong crowd, acted up. You could just tell he went his way.
Okay. Do you, when he was in and out of foster care, did you ever see his birth mother come around?
Rarely.
Okay. And was there ever any counseling provided to Brandon about the situations either involving his grandfather or the situation with mom and things like that you're aware of?
No.
What are you asking the judge to consider in regard to Brandon's sentence? You understand he was convicted of this murder charge, and all we're here today to do is have the judge determine what his sentence is going to be.
All we can ask is mercy on his sentencing.
Okay. And obviously there's a family involved on the other side, right? That is grieving and hurt by the situation. I'm sure you understand
Yes.
their perspective, right? You're
Yes.
just asking the judge to consider some sort of leniency.
Yes, we would.
I pass it. Witness.
Let's stay.
No questions, Your Honor.
All right, you may be excused. I'll call your next witness.
Let's rest.
All right, state any rebuttal witnesses.
No rebuttal.
All right, defense, if you could have the trial court certification signed and tendered to the court,
That
please.
you have a right of appeal. Yeah.
Thank you, counsel. All right, state, do you have argument?
Yes, we do, Your Honor. We'll reserve our argument.
All right, defense argument.
Judge, in regard to the extraneous cases that the state has introduced, I think there's still the same standard of proof that's required to believe it beyond a reasonable doubt. I think clearly the fact there's no witnesses provided in regard to those cases, I don't think the court can place weight on those. One case, where they found this Miranda Garcia's ID, she's charged with her own separate murder charge. So I think if we look at what we should be looking at is this case here, and obviously the jury made its determination based upon the evidence. I would ask the court to consider Mr. Guzman's problematic childhood, and obviously there are people who have the same situations. And everyone handles things differently. This sounds, particularly with foster care and the abuse he suffered, I think would be, I think, an explanation for how he went off track. I'd ask the court to assess a sentence of 35 years. I think it's appropriate based on the circumstances, and I think it adequately assesses punishment on this case.
All right, State?
Yes, Your Honor. In this particular case, Your Honor, the extraneous offices that defense counsel brought up in their close, even if you discount the fact that all the shell casings from .45 caliber weapon all matched to over 3 months of different crimes of aggravated assaults and murders, you can throw all those out and don't even determine that in your determination on this particular case, because if you just look at the case that he was convicted of murder, in this particular case, he went into another person's home, shot them in the face, started collecting items in a blanket, TVs, and other items of value, and started stealing from that individual after he shot him in the face and left him in the bathroom to die. Then was rifling through a closet when the other individual, Mark Hernandez, that did come in and testify. And you're aware that the trials and tribulations that that individual had to go through, because he entered and then he was also shot once in the chin and the neck and then once in the back. The fact is, the trauma that he went through alone calls for a much more sentence that is appropriate, because the fact is he almost died on that in that apartment building, in that room, because of this defendant going over there with his .45 caliber gun. He shot him, left him on the ground to die, and ran off like a coward. The fact remains is that could have easily been another death. That would have been a capital murder because multi-death. Now, on top of that, he's stealing from them. So that's additional information about what the character of this individual is. Runs away in the dark, and the jury came back with an appropriate guilty verdict. So the state's position is, due to just the circumstance of this murder alone and the aggravated assault that he committed while he was committing this murder, is it appropriate for a life sentence and only a life sentence for this individual?
Right. Mr. Guzman, is there anything you wish to say?
I'm menacing, Your Honor.
All right, Mr. Guzman, if you wish to say more than that, you'll be called to testify and the state will have a chance to cross-examine you. So do you wish to say anything or no?
No.
Okay. All right, I heard all the evidence during the jury trial. I remembered everything. I've also had a chance to read the PSI report. I want both parties to know that I listened to each of the witnesses and I always internalize everything that they're saying. Murder charge, the range of punishment is 5 to 99 years or life. That's what the legislature has told us the range of punishment is for that. So that means that every murder case is not a life sentence case. And so I look at both things. Mr. Guzman, as you know, I've been a defense attorney and a prosecutor. So, and I've handled many types of cases. So I look at everything. I heard all the witnesses and I heard all the punishment witnesses. I understand what your family said with regards to your upbringing and what happened to you and what happened to them. All right, so this is what the court will do. The court is going to sentence you to 70 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. Is there anything else from either side with regards to sentencing?
Not from the
defense, Judge.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yeah.
All right, because this was not a plea bargain agreement, but a jury trial, you do have a right to an appeal. All right, and Mr. Maurer, with regards to any appeals, are you going to be handling the appeal?
No, Judge, I'm going to file a notice of appeal and motion to withdraw.
All right, so Mr. Guzman, what will end up happening is there will be an attorney appointed to you unless you hire one for purposes of your appeal. So we'll make sure that that's done. Yes.
Like that whole process started.
Well, your attorney is going to file a notice of appeal. He's letting the court know on the record that he's going to file a notice of appeal. Then as soon as that's filed, what will end up happening is an attorney will be chosen from the will to handle the appeal. The court reporter will be asked to prepare a record for that. And so this court reporter who's heard this punishment, she will prepare her record, and the court reporter who heard the trial will prepare the record, and then both sides will get a chance to prepare a brief, and the state will get a chance to answer whatever brief is prepared by your appellate counsel. All right, is there anything else, Mr. Guzman?
Oh, man.
All right, state, is there any victim impact?
Oh, let me check. Yes, there is, Your Honor.
All right, Mr. Guzman, my understanding is there's going to be someone who will speak to you. I require that everyone treat everyone with respect, so they're going to treat you with respect. Just listen to what they have to say.
Brandon, I know you don't wear that mandate, otherwise we wouldn't be here today. Me and my siblings had a rough upbringing, just like any normal human being. Sometimes, something I just want you and your family and the court obviously to know, my brother would have never done this to you or your family, or to anyone for that matter. Because although we had a rough childhood, we still had a lot of respect and compassion. I'm not saying I hate you. I wish you the worst. I just hope you understand what agony and grief you brought to my family. With such pain, it becomes an addiction, and a lot of my family members use alcohol or drugs to cope with the loss of my big brother. I hope you take this time to reflect on what type of human you have been in this world. And I truly pray you feel remorse, not just for yourself, but regret that you took an innocent life. My mother's only son, Justin Matthew Lawrence. And I hope my words aren't just words to you. See, my older sister has 3 girls, and they state all the time how much they miss their uncle or could have spent more time, make more memories with him. I just had a daughter. My brother will never get to meet her. Our kids were supposed to grow together, and now my brother will never have a bloodline. I just want you to understand you traumatized our family, and it's something you shouldn't just glorify. You ruined your own life just as much as you ruined ours. I came here from Nebraska thinking this would be our family's closure yet. We are still left with many questions. You know what you have done. Let it eat you alive until you aren't content with yourself.
I come from the same spot. I grew up in the projects too. Same things happened to me, the same things that happened to you, siblings, your cousin. I made it out. Sad that you did it, but your family does have a chance. Hopefully they see you and decide to make better decisions. I have family members that are in there that did the same exact thing you did. I don't get to see. And I don't think that they should have got 5 to 30. They're a hazard to the civilians outside. They have a chance. The only thing that's messed up about all this is that they still get to talk to you, get to update you. So you still get to be an uncle. You still get to be somebody. Justin doesn't get that chance. We don't get to leave here and be like, hey, we got Justin. We still don't. To me, it's not really about how long you're gonna be in there. It's more you find peace with yourself. I've had the same anger that you had. That happened to me in my childhood. I've just been blessed to have the knowledge to keep going and actually get a job that covers counseling, therapy, stuff like that. You have a chance to get that for free back there. I hope you really do decide to take that and try to make a difference to help other people who don't get a life sentence to come out here and be different. You still got a voice back there, and I hope you use it to help other people not go down the same path you did.
Thank you.
Thank you. John Casanova Paez, John Casanova Paez. And who was the person in the courtroom talking about, I love you, daddy? Who is that? Come forward. This is a courtroom.
Yes, ma'am, I'm sorry.
If you want to talk to somebody, you need to talk to them at the jail. This is
Okay.
not visitation. Do you understand?
Thank you. I'm sorry.
All right, so you're excused from this courtroom in this courthouse.
Thank you.
All right, John Alberto Casanova Paez, come forward, please. All right, where's your attorney?
She had to go, somebody else is gonna come.
All right, we'll call you back up once she comes back. Is the attorney here on Oscar Martinez? All right, is the attorney here for Christine Garcia?
Yes, Your Honor.
All right, if you come forward. All right, have you all conferred?
Yes, Judge.
All right, is there an agreement?
There's not, but we have a tentative agreement in the sense that she's going to plead true and then go over to the court.
Okay. All right, could everyone please whisper? Court is calling 2022 CR 2843, State of Texas versus Christine Marie Garcia. Can I have parties announced for the record for the state?
Michael Villarreal, the States.
Defense,
Christopher Castro for the defense.
are you Christine Marie Garcia?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Christine Marie Garcia who was placed on community supervision in 2022 CR 2843 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on June 28, 2022 for a term of 3 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 2, on or about the 24th day of February 2023 in Bear County, Texas, the defendant Christine Marie Garcia did then and there failed to submit to drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
Sure.
State.
Violated condition number 4, it's on the second page, second one, Judge.
Okay.
On or about the 13th day of December 2022 in Bear County, Texas, the defendant Christine Marie Garcia did then and there failed to conduct herself in a proper and orderly manner when reporting to recovery healthcare to submit to drug testing in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
Violated condition number 15, on or about the 3rd day of January 2023 in Bear County, Texas, the defendant Christine Marie Garcia did then and there failed to attend and complete the intensive outpatient program with BCCSCD in violation of condition number 15.
How do you plead to that? True or not true?
True.
The state would waive and date their meeting out.
Any objections to the waivers?
No objections, Your Honor.
Did you understand by pleading true to violations 2, 4, and 15, the court could find it true, grant the motion, and sentence you up to 3 years in prison and up to $1,000 fine? Did you understand that?
Yes.
Knowing that, do you still wish to plead true to violations 2, 4, and 15?
Sure.
Now, my question is, knowing that I could sentence you up to 3 years in prison, do you still wish to plead true to violations 2, 4, and 15?
Yes.
All right, the court will find violations 2, 4, and 15 true. Is there an agreement?
There's not an agreement, Judge. The state is recommending and asking the court to deny the state's motion to revoke community supervision, but we are asking the court to modify her conditions of probation to include SATIF. Clearly, outpatient is not working. She's not doing her drug testing. And when she is going to do her drug testing, she's not complying and being respectful to those around her. So it's a safe position that she needs to be in a lockdown facility where she is not having choices about her sobriety. And so we are asking that you deny the motion, however, alter and amend her conditions to include the SATIF program.
Defense.
Judge, we're asking that she be allowed to continue on IO with the intensive outpatient treatment. Although she had not started, she was under a regimen of methadone prescribed to her by what's the name of it? New Seasons. That was the reason for the outburst at the clinic, Judge. As far as the missed UAs, she did bring that to the attention that she could not afford the UAs, in which I think starting March, that was amended to once a month to help her financially. She has two young children are separated between her mother and her grandparents, that she is the primary guardian for, that she needs to take care of, Judge. She would not be able to do that if she's in SATA for the next 6 months plus the 5-week waiting period.
All right, so Ms. Garcia, I'm gonna give you a choice. Sometimes I can give people choices, sometimes I cannot. You can either go into inpatient treatment or you can go to prison. Which would you prefer?
We'll go to inpatient.
All right, so the court will deny the motion, alter and amend conditions to include SATA. And she's to remain in custody until she is transferred to SATA. And probation, we can do a referral to drug court as well, or have they already rejected her?
They've already rejected her, Your Honor.
I'm sorry.
I apologize.
Out of the way.
Thank you. Yes, so I would refer you to felony drug court, but you did not contact them. So you're going to SATA and she's to remain in custody until transferred to SATA.
Thank you, Judge.
All right, thank you. Are the parties here on Joe Gonzalez?
Yes, Your Honor.
Yes. Court is calling 2022 CR 9961, State of Texas versus Joe Gonzalez. Could I have parties approach and announce for the record for the state?
Michael Miller, behalf of the state.
Patrick defense? Hancock
for Joe Gonzalez.
Are you Mr. Gonzalez?
Yes.
All right, you entered a plea to count one on March 23rd. The court found there was sufficient evidence to find you guilty. You applied for deferred adjudication. According to your plea bargain agreement, punishment is to be assessed at 8 years in the prison. State is opposing your application. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections?
No objection to the state.
All right, any objections to the PSI report?
No, Judge.
All right, state, do you have any witnesses?
No witnesses from the state, just argument.
Defense?
Judge, in advance of today, we filed a motion to supplement the PSI with some character letters. And
Yes.
so we want to be able to direct the court's attention to that. You've had a chance to look at it, Your Honor.
All right, and I've read those documents in anticipation, and I always say never anticipate. But state, if you have any objections to the court having read those documents that were submitted, the court will totally disregard those.
No, Judge, and Mr. Hancock was good enough to submit those electronically to us early enough for us to review, and we have no objection.
All right, the court did review those documents, counsel, and probation officer, Ms. Abrams brought those to my attention.
Thank you, Judge.
All right, defense, do you have any witnesses?
Judge, I don't. We'd just like to make an argument at the appropriate time for
All right.
for adjudication.
All right, state?
Yes, Judge. So obviously, this court handles plenty of child sex cases, and from the PSI, you can tell that this is, I don't want to say typical, unfortunately, but this is, there's nothing necessarily extraordinary about the facts and circumstances of the case. For me, the most aggravating factor of this case is obviously that there's a child involved. There's multiple allegations of different types of sexual contact as per the stipulations. But this is a position where the state has had to advocate for this child because as per the stipulations, the mother of this child hasn't always been compliant or believing of this child. So the state has had to step in order to advocate for what is justice for this child. And I don't think that benefits or weighs the defendant or weighs towards the defendant in this case. obviously, people are victimized for their vulnerabilities, and particularly in this case, it seems like that is a particular vulnerability in this case. He has been given the benefit of a very good bargain, and anticipation of not having to resolve any issues of having to get this child to court, which I'm sure that we would have been able to, but without causing any further trauma to this child. So the state is asking that you deny the application in this case and sentence him to the full 8 years because he's been given a very good benefit of the bargain as it stands already, and 8 years is definitely it's the limitation of this court, but he deserves more than that, to be quite frank. But with all the facts and circumstances, we're asking that the court sentence him to 8 years.
All right, defense.
It's cap of 8, correct, Judge?
Yes, it's a cap of 8.
Judge, the state's obviously made its point, and as I've heard the court say this morning in other cases, obviously the court has experience from the defense side and the state side. My client accepts responsibility. I don't think he did it so artfully in his PSI, Judge, but we did collect what we thought would be appropriate letters for you to reflect on his character. Here, Mr. Gonzalez has spoken by his mom, his stepfather, and his cousin and other folks in his communities being a good father. The stepdaughter is the complainant here, but he also has a biological daughter, a biological son, and a daughter that was adopted by the mother of the complainant. So that's another child. I think they sent a letter to the court saying that they missed their dad, and they obviously expressing their support for him, even at their young age. He has no criminal history, Judge. I think there's a prior arrest for a drug case some years ago, back in 2005, but for the most part, he doesn't have a drug or alcohol problem. He went through the TAP evaluation. They weren't making any recommendations. He is a working, productive member of our community. I think that to be placed in the community on deferred adjudication, Judge, is not a leap here of that would insult anybody. I think he could benefit from counseling that this court can provide, sex offender terms of conditions that he can comply with. He's a good candidate for deferred adjudication because he has no drug or alcohol problem. And he does care and support his children, the other children in his family. I think there are some dynamics regarding the mother, Judge, and obviously, as the prosecutor said, those dynamics were taken into consideration. I believe that he would be a good candidate for deferred adjudication and would successfully complete it. I know there are cases where that's not a good idea, but here it does seem like he could be a constructive member of the community, remain in the free world, and take care of his obligations with his other children. So, Judge, we'd ask for you to seriously consider his application for deferred adjudication, or in the alternative, recognize that he has a taste of incarceration. He's been sitting here for 6 months in jail. I think which should motivate him to do better on deferred adjudication. But in the alternative, if you don't consider that, to recognize his acceptance of responsibility and give him something less than 8 years, Your Honor.
All right, is there anything you wish to say?
No, ma'am.
All right. All right, the court is going to deny your application, find you guilty, sentence you to 8 years in prison, give you credit for any time served. There's to be no contact with the complainant or the complainant's mother. There's going to be Chapter 62 registration and no contact with minors. All right, thank you. Just one moment. Did you review the document entitled Trial Court Certification with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. All right, Kevin Luna.
I've conferred with the prosecutor, Mr. Garahan, on this case. It looks like we are still missing Still missing quite a bit of discovery, I believe, Judge, and we're also trying to coordinate together to see if there's a potential.
All right, what,
We're hoping for another discovery compliance.
what discovery is missing?
Judge.
Made a list.
And it's, it's a list that we had previously that I'm missing quite a few of the things, there's a lot of DNA, part of things that are being tested that haven't come back. And there's also a sexual assault kit that may or may not be associated or relevant, but needs to be obtained.
All right, so I'm going to tell you what I have in my last notes, and I think you all may remember.
Oh, I
this.
know. I know what you don't have to tell me. I know what you have in your notes.
From February 13th. State and defense agreed to 60 days. Court granted 75 days. So,
But, oh, there are more.
so here's what I'm going to do. I'm going to give you a 45-day reset. And state on that 45 days, you need to let the court know whether or not you all, I don't know if this
It
is
is
death
but
penalty.
I believe he was 17, Judge.
Was he underage at the time? Okay, so there's no death penalty issue, but we're gonna come back in 45 days. At the 45-day mark, if you all don't have the DNA, then you all need to start subpoenaing people to be here to explain to the court why the DNA is not ready and when they think it's gonna be ready. Okay, do you need your client brought out?
I don't, Your Honor, but I was going to talk to him as soon as they brought him out for a bit.
Okay,
Yes, he's on his way.
all right, Ms. Fergus, can I have a 45-day reset on Luna for discovery? All right, June 22nd.
Thank you, Judge.
All
Thank
right,
you,
you're
Judge.
welcome. Do I need to write in here that you all asked? I should have put you on the spot to make you ask for 2 weeks, and then I'll be like, I gave you 45 days.
I appreciate you did.
You can still put it in there.
Okay, I'll put that in there.
Approach very quickly.
Yes,
Mitch, I had a guy that you, they were gonna bring over for me on a bond hearing on a Guillermo Constantio, but he didn't make it on the docket. And you're not in tomorrow, are you?
yes,
Can they bring him over tomorrow?
yes, I think will we be here? Because we have a jury trial. Yes, so, yes.
I can be here at 9.
Okay,
It shouldn't take very long.
all right, thank you.
thanks.
All right, Jess Moffness is the attorney here. John Deaver. Oh, and Robert, if, I don't know if you and the state have decided what to do with the rest of the cases for Mr. Guzman.
Well, Judge, I'm gonna dismiss them all.
Okay,
I'm just trying to get somebody to sign them.
okay. All right, court is calling 2023 CR 0222, State of Texas versus John Wesley Deaver. Can I have the parties announced? Deaver? All right, thank you. Can I have parties announced for the record for the state
Lindsay Shaw for the state.
defense?
Good morning, Your Honor. Daniel De La Garza.
All right, and are you Mr. Deaver? Are you Mr. Deaver?
Yes, ma'am.
All right, have both parties had a chance to review the PSI report, state
Yes, ma'am.
defense?
Yes, Your Honor, and I actually added a couple of addendums to it. D 214, a letter of Mr. Deaver requesting BTC court, which we'll talk about in a few minutes. A letter of support and stuff, and the like. Nothing real long. I wasn't trying to include.
Well, with regards to the VTC court, have they accepted him or no?
Your Honor, it's kind of unfortunate. I think he's a very, very, very good candidate for it. However, in talking to some of the administrative people that run it, they're telling me that they're full. And so it's kind of, it's unfortunate, I think. But
Do you know what's happening with VTC? Are they full? All right, Ms. Ferguson, can you see if John Herman is here? Because I would like to know what my options are because the state is opposed. Yes. Okay. All right.
I would like him to consider for it if it's possible.
Yes. So, yes, if you all will just have a seat, I promise we will get to you.
As long as the court needs. Thank you.
Okay,
Your Honor.
thank you. And Norma, can you also check with felony drug court as well? To see if they have room. I'll email them too. All right, thank you. Hi. Hi, it's good seeing you.
She might need to file that. Can judge that file on the board? Maldonado.
Maldonado.
Okay. He's in jail.
This judge won't take it unless he's out.
Oh, okay, they're having,
Yeah, you have to wait till he's coming.
okay.
Okay, well. I just, he's on there, let's see.
Oh, you can ask for him.
Okay.
Use it required.
We can do them now. I'll call them in line, just have them put the files and I'll take it up. And Bashan, I smell, I don't drink alcohol at all, right? I'm smelling alcohol. There's somebody. There's some alcohol smell going on in my life right now. I know. Yes. I'm like. Camilo Rodriguez. All right, they gave me the follow. You all ready to proceed?
Yes, sir.
All right, the court is calling 2022 CR 2234W, State of Texas versus Camilo Richard Rodriguez. Can I have parties announced for the record for the state?
Travis Banks for the state of Texas.
Defense,
Rick Crow on behalf of the defendant.
are you Mr. Rodriguez?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Camilo Richard Rodriguez who was placed on deferred adjudication in 2022 CR 2234W for the offense of violating a bond or protective order assault on March 7, 2022 for a period of 3 years? Is that you?
Yes, ma'am.
State?
Violated condition number 2 on or about the 19th day of September 2022 in Bexar County, Texas. The defendant Camilo Richard Rodriguez, defendant there, failed to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
And the state will waive and abandon the further allegations.
Any objections to the state's waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, find you guilty, sentence you to 10 years in prison and up to $10,000 fine? You need to speak up.
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there an agreement?
Yes, Your Honor, the agreement and the state's recommendation, should the court choose to follow it, is to deny the motion and to alter and amend the conditions to add a drug patch, refer the defendant to felony drug court. The defendant should also show proof of employment and residence, and there would be zero tolerance on any further violations going forward.
Defense, is that the agreement?
That is the agreement.
All right, Mr. Rodriguez, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Camilo Richard Rodriguez.
Do you have employment?
Yes, ma'am.
Why haven't you turned over that information to probation?
I have, I believe that I turned it in late, but I've been employed for a year, almost on May the 19th. And I have, I provided the address since we just moved locations, and I provided check stubs, and I can do it today as well, with any kind of proof that you need.
All right, they're saying they don't have your residence. Have you provided them where you live?
Yes, ma'am.
All right, the other thing is, why won't you stop using marijuana?
It helps me a lot with anxiety and depression and PTSD, partially from an accident that I had in a relation. And it was something that I was dependent on for a while, and I realize now that it's not important in my life. I have a baby boy on the way that's due on October
I
20th.
mean, you should have realized that before. You're looking at 10 years in prison.
Yes, ma'am. Yes, I realized that was a huge mistake, and I solemnly swear not to continue that with those habits and to move forward with that completely out of my life and fight for my freedom and so I can see my baby boy and be there for my now pregnant girlfriend, who I hope to be my wife soon, and continue to be there for my family who needs me very much.
Does your pregnant wife, girlfriend know that you're on deferred adjudication for violation of bond or protective order?
Yes, ma'am.
Okay, all right. All right, this is what the court will do. Deny the motion, alter and amend conditions to include a referral to felony drug court, a TAP evaluation if that's needed. If he's not accepted to felony drug court, follow the recommendations of TAP evaluation. He's going to provide proof of employment and residence. I'm going to want the field visits 1 time per month until further notice. I'm going to want parenting classes. And Mr. Rodriguez, probation here in this court is very serious. You're going into custody today. He's going to have his felony drug court evaluation and TAP evaluation while in custody. Once that's completed, he'll be released. Is there anything else?
I think that is a statement.
All right, thank you. You need to do better. And from here on out, you say that you want, we're off the record, you say that you want to be in your child life, then guess what? From here on out, everything that you do, you need to ask yourself, is this something that could result in me going to prison for 10 years? And if the answer to that question is yes, then you shouldn't do it. If the answer to that question is maybe, then you shouldn't do it. I always tell everybody in this court that communication is key. If there's an issue with probation and they don't solve your issue, come to the court. I tell everybody that. We're here from Monday to Friday. The fact that you're out here just living your best life, violating conditions of probation, I don't allow that, especially when communication is key in this court. All you had to do was call probation and say, this is why I'm using marijuana. Can you give me some mental health treatment? Court would have done that. And if probation wouldn't have responded to that, I would have done that. You would have come to court. I would have asked Ms. Abrams, can we have his probation officer zoom into court so we can take care of this? You just can't be on probation out of this court and not follow the rules, because then you're not on probation. You just have a piece of paper and you're doing whatever you want to do. You understand?
Yes, ma'am.
All right, good luck to you.
Your Honor,
Yes,
is it possible that he can have a little bit of time to get his affairs in order to,
no,
no?
because he could be going to prison right now. All right, the court is calling Christian Angel Segovia. All right, court is calling 2023 CR 0292, State of Texas versus Christian Angel Segovia. Can I have parties announced for the record for the state?
Lindsay Shaw.
Defense?
Melissa Christian.
All right. This is a case where you entered a plea on March 28th to count 1, count 2, count 3.
I think it was a reduction to a robbery.
Yes, it was. Just one moment. No, it's not listed as a reduction in here. On the plea paperwork, it's not listed as a reduction. Let me see what the indictment says. If count 1. Counts 1 and counts 2 and 3 are all aggravated counts. There's not a reduction, but according to the plea, the state is recommending, but there's no reduction. Was there a
In the
reduction?
I believe there was, Judge. In the PSI, it shows it's to robbery.
All right, there's an issue then with the plea paperwork.
Pull it up to Judge.
All right, so if y'all want to step back and confer over that. Because there's no reduction listed in the plea paperwork. And so if you'll have a seat, they're going to review that. Gilbert Pruitt. Court is calling 2022 CR 9442, State of Texas versus Gilbert Pruitt. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense?
You think okay for Mr. Pruitt?
Are you Mr. Pruitt?
Yes, ma'am.
All right, Mr. Pruitt, you entered a plea bargaining agreement that required no application, and you entered a plea to unauthorized use of a vehicle. According to your plea bargaining agreement, you agree that if you did not appear for sentencing, then you will be subjected to the full range of punishment.
Right.
And you did not appear for sentencing. So your full range of punishment is up to 2 years in the state jail facility. So is there a reason why I shouldn't sentence him to 2 years in the state jail facility as opposed to the 14 months?
Mr. Pruitt has been having some problems with drugs. And he also had, during this period, he also had some family problems.
All right, Mr. Pruitt, would you like to raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand. You were scheduled for sentencing on December 12th at 9 a.m., December 12th, 2022. Did you appear? That's either yes or no.
Yes, ma'am.
Did you appear in court
Oh,
for
no, ma'am.
sentencing?
No, ma'am.
All right. Any other questions from either side?
Nothing from the state.
All right, according to your plea bargaining agreement, you're subject to the full range of punishment. If you did not appear, you did not appear. The court previously stated that you were found guilty. The court is finding you guilty. The court is sentencing you to 2 years in the state jail facility. Court will give you credit for any time served. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
I sure did, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, your counsel tells me you have drug issues. If you would like, I can make a request that you're placed in the therapeutic community. I can't order that, but if you request it and they see that I requested it, they may place you in that. Do you wish to be placed in that?
Yes, ma'am.
All right, so I'm going to request the therapeutic community. It will be completely up to them because I have no jurisdiction to force them to accept you. So it'll be completely up to them. But I will tell you this, once you're released from custody, there are so many places now that are free if you have a drug or alcohol problem. If you can continue on the path that you're on, what's going to end up happening is either you're going to end up dead because you're going to get a bad batch of drugs, or either you're going to be in and out of prison and you're going to wake up one day and you're going to have spent the majority of your life in prison. And what I can tell you is about drugs, drugs wear on your body. I have friends who are in recovery and who are sober. And now they say, because I put my body through so much, I have to be 100% healthy. So they don't do the sweets, they don't do processed, they can't enjoy any of that. I probably shouldn't be enjoying it as well, but they don't eat the ice cream, they don't do any of that because they said I damaged my body so much. I got to be 100% on being healthy.
Right.
All right.
Yes, ma'am.
All right. Good luck to you.
Your Honor, I
Yes.
don't see my client's signature on this document.
All right. If you'll have him sign it, please. And Caroline, if you have him sign this as well, please.
I'm sorry.
All right, Christian Segovia. All right, so before we go on the record, Ms. Christian.
Yeah, it's okay, Judge. I'm okay with the aggravated robbery. I
All
think
right.
I got thrown off looking at information in the PSI.
All right. All right, we're back on the record in 2023 CR 0292. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes.
Any objections to the PSI report, state?
No, ma'am.
Defense?
No, ma'am.
All right, any witnesses, state?
No, ma'am.
Defense, any witnesses?
No, Judge, I would like to just point out a couple of things for the court. I know the court reads these very carefully, but I would like to bring to the court's attention that Mr. Segovia really doesn't seem to have any drug or alcohol issues, that he acknowledged his guilt. He was very forthcoming in the PSI. Also, you will take note that he was the one that did not have the knife. He was actually with someone that produced a knife and it was the other person's idea. And we understand the law of parties, but Mr. Segovia is just asking the court to go ahead and follow the plea bargain that we have with the state of Texas.
All right, and there's a restitution amount of $849.99.
There is that amount, Judge, yes.
Any objections?
It was my understanding that they had gotten the phone back, but I might be mistaken about that. And maybe if we could have a hearing on that if necessary.
All right, counsel, I'm going to order that because I'm reading the PSI report and there's no information in the PSI report or in the stipulations that the phone was returned. And I see as a part of your plea bargaining agreement, it states the restitution amount of $849.99. That was what you all agreed on in the plea bargain agreement.
That's fine, Judge.
Okay. All right, anything you wish to say? Do you have children?
A little boy on the way.
How are you going to support yourself?
I'll work. I have a really good paying job.
Okay, you're going to have to speak up. I can't hear you.
I have a really good paying job. I work.
Who are you going to be living with?
My girlfriend and her grandma.
I don't understand why grandmothers allow their grandchildren, which means if her granddaughter is staying there, that means that her mother is not in the picture. I'm not going to allow you to live with this grandmother.
Her mother's in jail. Like her mom was never there.
Yeah, see, that's what I'm talking about. There's a cycle that's going on here where you have grandparents who are raising children, and then those children are bringing boyfriends into the home, having children with them. And now the grandparent not only is raising their grandchild, but they end up raising the great grandchild. It's like the grandparent is not supposed to be the person who's taking care of grandchildren and great grandchildren. And we all know that's what's going to end up happening.
She's not taking care of me. I mean, I pay bills there. I stayed there for like a couple of months already.
Mm-hmm.
Judge, if I may,
yes,
Mr. Segovia has had kind of a difficult upbringing, and I think that was touched upon in the PSI. He was raised by grandparents. He hasn't really had much contact. He has no contact with the mother. He's had limited contact with the father. While he's been in jail, really the only support system he has had is this girlfriend, and the only stable place that they have to live is with the grandmother. And that has provided some stability to them. He has been contributing to the bills and been paying when he was out. And he actually was pretty consistent in getting a job. He had a job at a fast food restaurant, and then somebody told him that he could make more money in construction. So he went and had a job there. So he's worked very consistently. He's indicated that he would like to get his GED to improve his position. But I really do think it would be detrimental to Mr. Segovia if this stable living place where he has been living would be taken away. And I can understand if the court maybe wants to attempt some kind of a transition period for Mr. Segovia and his girlfriend and their child to be independent, and perhaps with the help of probation, they can do that. But I think at this moment in time, in putting him on a long-term deferred, that it would probably be very detrimental to him to take away a stable living situation.
All right. With regards to this cell phone, it appears that the cell phone, I guess, was paid by Angie Camacho. So I'm just going to do restitution at $849.99 to Angie Camacho or Alan Hernandez, because I don't know which one paid for the
That's
phone.
fine.
In count 1, count 2, and count 3, those counts will run concurrently. The court will sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, proof of employment within 15 days, no employment as a home health care provider with minors, 120 hours of community service restitution. I'm going to order parenting classes with Triple P. Once that's completed, the community service hours will be deemed to be satisfied. You're going to either get a GED or some sort of trades certificate for a trade school, $1,000 fine, probated. With regards to restitution to Jathlyn, Jathyn Cantu, the court does not have any documentation as to what that restitution is. So the court is not ordering restitution to that person. It's agreed that you plead as a party with Joe Vitala. There's to be no contact with Damian Ortiz, Ortiz, Alan Hernandez, and Jathan, Jathyn Cantu. I'm going to want field visits one time per month until further notice. What is his grandmother's name?
I don't know the name.
You don't know the name of the person you're living with? How can you not know the name, counsel? How can you not know the name of the person he's living with?
What's your girlfriend's name, Mr. Segovia?
City
What's her last name?
Martinez.
Absidy Martinez.
So what's the grandmother's name?
I don't really be over there like that. I mean, I live there, but I work all the time.
How can people not know who they're living with, counsel?
I don't know if it's listed in the PSI. I think it's just listed as the girlfriend's grandmother.
This is how people end up in trouble. You're staying with people, you don't even know their names, and you're acting as though you and this girlfriend are going to be together for the rest of your life, and you don't even know her grandmother's name, and you're staying in the grandmother's house. All right, probation. He's not, what's your girlfriend's full name? Ashley what?
Absidy
Absidy.
Martinez.
Absidy Martinez. Okay. Defendant is not allowed to reside with Absidy Martinez or her grandmother until he provides the full name of the grandmother. People need to know who they're living with. So there's to be no contact with Absidy, and I'm assuming that's ABCEDE.
I think it's ABCDE.
ABCITY.
I'm sorry, say it again.
Oh, Absidy, ABCITY.
Yes, ma'am.
Okay, so there's to be no contact with Absidy. You know, I represented a child once on CPS side, and their name was Absidy, and it was ABCDE, which makes it easy for a child to spell their name in school because it's the first letters of the alphabet. But so there's to be no contact with Absidy, ABCITY. Last name, counsel?
Martinez.
Martinez or Absidy Martinez's grandmother until defendant provides full name of the grandmother. Defendant is to provide address within 7 days of release from custody. I'm going to want regular UAs. There's no request for TAP evaluation. Probation, is there anything else that's needed?
Your Honor, his TAP evaluation was complete.
Okay. It just says weekly UAs.
Yes, Your Honor. The only other thing I was gonna ask for his community service hours are gonna waive anything for his GT or trade school certification.
No. The community service hours will be waived once he completes parenting classes, but the GED and trade school, he's just gonna have to get that.
Thank you, Your Honor.
All right, is there anything else you need from the court to be successful? You need to speak up. All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, and counsel, in each count, there's an affirmative finding of deadly weapon.
Yes, Your Honor.
All right, thank you.
Thank you, Judge.
Hi.
Other side, sir.
My understanding is there's no room for,
For veterans, right now, so right now the judge still has the pause, but I'm making a list of referrals
He's gonna be hired, we lost some staff, well, we've made some changes, so I'm waiting on someone to be hired to help me out. That's when he's gonna have to reopen it up, so as far as I know, it's about a couple of weeks.
A couple of weeks?
Hopefully, it's when I can open it up. I got a long list for referrals. I know I have a few of yours.
All right, can you talk to his person before you
Yes.
leave?
Yes, ma'am.
All right, he's gonna talk to Mr. Jeever. And can we put him at the top of the?
Absolutely. I'll
Thank
move
you.
As quickly as I can.
All right, so
Thank you,
he's
ma'am.
gonna talk to him, and then once he speaks to him, then come back.
Yes,
And
ma'am.
I'm looking at resetting this because I want to know what all my options are.
That sounds great.
All right, thank you.
We'll do that right now.
May I approach on the housekeeping issue?
Yes.
Just, I don't know how you like to do this, but we have a sentencing today with a cap of 6, but me and the prosecution have 3 to 5. Is there something you want us to do, like?
Oh, you all have to redo your paperwork.
Just redo the paperwork?
Yes.
And then resubmit it that way?
Yes,
Thank you, Judge.
just initial the plea agreement.
Okay.
All right, who's here on it? Julio Chewy.
Your Honor, present, ready.
Okay. Court is calling 2018 CR 10426W, State of Texas versus Julio Chewy. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Linda Corley for Mr. Chewy.
Are you Mr. Chewy?
Yes, ma'am.
Showing you what's entitled application, motion to enter adjudication of guilt and revoke community supervision, and supplemental motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Julio Emmanuel Chewy who was placed on deferred adjudication in 2018 CR 10426W for the offense of manufacture or deliver a controlled substance penalty group 1, 4 to 200 grams on November 28, 2018 for a period of 3 years? Is that you?
Yes, ma'am.
State?
Violated condition number 1, on or about the 19th day of March 2023 in Bexar County, Texas. The defendant, Julio Emmanuel Chewy, committed the offense of possession of controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
No, Your Honor, we're proceeding open to the court.
All right, state, what are you requesting?
We're requesting revocation and 10 years TC.
All right, state, I'm sorry, defense, what are you requesting?
Your Honor, we're requesting that you either allow him to continue on deferred or at least if you find it necessary to convict him, to allow him to have another chance at probation. We do have some context for you, and I would like to talk with you about his current status. So Judge, he had quit reporting. He had reported for a while. I believe he was put on in 2018, and he had been reporting. He quit reporting. It was actually during the COVID period. Things were confusing, and clearly he hadn't been doing his drug testing, and that was an issue. Since then, he has gotten more stable. Now the state is dismissing the new case, which he did plead true to. So there is the issue of the drugs, Your Honor, but he has been wearing a drug patch. He has been on pretrial for a while. He hasn't had any violations on that. So he's done a good job on staying off of the drugs. And I think that was really what was his main issue prior to that. So he has tried to make a showing, Judge, that he can complete probation if given a choice. He's got the drugs under control. He's not using anymore. And also, I believe he is currently working full time and does have a stable place to live. So we understand, Judge, that there was a long period in there where he was not reporting, but he has pulled himself together and he does want to get this right and go give him an opportunity.
All right, and with regards to the new number 1, how much drugs are we speaking about?
Judge, I would have to look that up. I didn't look into the specifics of the new number 1.
All right, counsel, do you know?
Yeah, I can pull that up for a moment.
What's the amount of drugs?
It is.
2 grams.
Yeah, here it is.
2 grams.
2 grams.
All right.
Is that okay, Judge?
Yes.
Okay.
All right, this is what the court is going to do. The court is going to grant the motion, find you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served, and the court will request the therapeutic community. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, ma'am.
All right, good luck to you. Therapeutic community, you will need to request it as well. It will not increase the length of time that you're in custody. You understand? Once you're released from custody, there are plenty of free programs where you can get a handle on your drug issues. You understand? All right. good luck to
Judge,
you.
may I just one more question?
Yes.
And we had had a possible agreement for 4 years, but he did want to go open because he wanted to ask for probation. Is there any way you'd consider to do 4 instead of 5?
No, I mean, his range of punishment is 5 to 99. 5 is the
I
minimum.
mean, I'm sorry, yeah, to, what did we have? No, that's fine, Judge. Never mind.
All right,
Okay.
thank you.
All right. Okay.
All right, who's here on Alfonso Christopher Diaz?
Does she still have my evidence?
Who's the attorney on Diaz?
But it's still.
All right, Mr. Diaz, come on down.
Judge, I also have a motion when you're ready.
Okay. Is the attorney here on Alfonso Diaz? No, we're ready to do it today. Who's the attorney? Ah. All right, state. Mr. Diaz is going to be recalled for May 9th. Defense counsel is ill. Deputy Laura, can you let that him know that the defense counsel is ill?
Your Honor, can I reapproach on Mr. Deaver?
Yes.
So I've talked to Mr. Herman and he says about 60 days he should get him in for the eval. He's already been at the top of his list.
Oh my gosh, we're not going to do 60 days.
That's what I was thinking.
All right, if you'll do me a favor, if you will call felony drug court
Okay.
and see if they have an opening. I sent them an email, see if they have an opening. I just want to know if I have certain options before I make a decision.
Yes, Your Honor.
So if you'll call have your client remain here, if you'll call felony drug court and see.
Yeah, right now.
Thank you.
Judge, another thing, isn't there a DWI court?
Felony DWI court is felony drug court.
Got it.
Yeah.
Perfect. Thank you.
Who's here on Jesus Santoyo? The attorney for Santoyo.
Your Honor, that's my turn.
All right, where is Santoyo? Come forward, please. All right, hello. So how are you doing?
Good, good. Oh,
Well, I mean, not good because you're seeing me. How old are you?
21.
All right, so here's the question for you. You are on deferred adjudication. Do you know the range of punishment for your offense is up to 10 years and, I'm sorry, up to 20 years in prison? Do you understand that?
Yes, ma'am.
All right, so the question you have to ask yourself is whether or not you're continuing to use is worth going to prison for 20 years.
No, ma'am. I have another kid on the way as well.
Then why kids or baby goats?
I have another child on the way.
So why are you continuing to use
Well,
drugs?
In the beginning, I'm not gonna lie, it was hard, and I was clean for 3 months. Then I slipped up at a function, and then
What function is this where people are smoking marijuana?
it was just for a fight, so it was really just me, my friend, whatever.
What fight?
The one with what's his name? Honestly, forgot, but it was a fight. I know it
So
was a
you're
fight.
going to a fight and you don't even remember the name of the fight, but that's worth you potentially going to prison for 20 years.
No, it wasn't worth it, but I just had slipped up that day, and then it takes a while for me to get clean. It took 3 months for me to actually get clean, so I slipped up then.
All right, they're asking that you go to SATA.
That one?
Yeah, they're saying that you need to go to SATA.
What is that? I'm not.
That's inpatient treatment.
I don't think, because I know I could stop. I stopped for those 3 months. Like I said,
Yeah,
I
but
just
you didn't do
slipped up.
well. I mean, you're stopping for 3 months and you're looking at going to prison for 20 years and then you continue to use. This states the defendant admits he is addicted to marijuana.
Yes, man. Like I said, in the first year, I'm not gonna lie, it was hard, but I finally stopped doing it. Like I said, I just slipped up. I thought it wasn't really gonna be, like it was gonna stay on my system for that long, because it wasn't a lot, but then it's like. I
Because you
said,
thought you would get away with it.
not get away with it, but I thought I'd just get it out of my system.
Yeah, that's you thinking you would get away with it. If you're thinking it's going to get out of your system before you test it. When you drug tested today, what the results going to be?
I'm not sure. I'm not sure if I still come out a little bit dirty. Like I said, it took almost 3 months for me. When I actually stopped doing drugs, it took 3 months because I was on my PO set. I finally came out clean.
Your Honor, may I?
Yes.
The last drug test that was done on 4/25 was positive for THC.
And do we have levels? Or no?
I can check it, Your Honor. So the only issue with that, Your Honor, is he was negative on his drug test on the 5th of April. Actually, he failed to submit. I'm sorry. He failed to submit on the 5th of April, March 14th. But in February, he was negative. So we won't have a baseline. I'll have a baseline, but I won't have any other information on the others.
All right, so this is what I want to do with him. He's going to do weekly testing, and it's going to be through the UA hotline. He's to be tested for levels. If those levels go up, we're not going to have another compliance hearing. It's going to be a motion to revoke filed. Do you understand?
Yes, ma'am.
And I'm going to want him to retake intensive outpatient treatment. And if it's not ordered, I did order parenting classes. Have you completed
Yes,
parenting
ma'am.
classes?
Yes, ma'am.
You didn't learn anything from it?
Oh, I did. I mean, I don't do it. It's not like I do it in front of my kid or like do it in the house.
A kid is a baby goat.
My child.
Well, here's the thing. The fact that you're doing it outside your house, you can't tell me that you don't come back into the house smelling like marijuana.
Oh,
Let me just tell you right now, I don't drink alcohol at all, but there is someone who came in this courtroom who smelled of alcohol. I don't know who it was, but it nearly knocked me out. So the fact that you are using marijuana, your child knows that you're using marijuana. And guess what? Children are going to end up teasing them because they're going to come to wherever they come to smell like marijuana. And if you have a child that's on the way, I guarantee you that mother is probably using marijuana, messing up her baby's brain. And when marijuana is used in the household, it messes with the baby's brain development. These are critical years and critical times for infants. Their brains are developing. They're soaking up everything. That's why they're super intelligent. When children use profanity, they get that from their parents or whoever's around them because they repeat everything. The fact that you're using marijuana, whether you think they know it or not, they do. And you're going to send your child off to school smelling like marijuana so other children can choose them about their pothead parent. Do you understand?
Yes, ma'am.
So you're going to get your life together. If those levels go up, what's going to end up happening is a motion to revoke is going to be filed, and you're going to be looking at 20 years in prison, and you're going to be possibly going to prison for 20 years. And people ask you why you're here, you're going to end up having to tell them because you wouldn't stop using marijuana. Your time in prison wasn't worth you giving it up, and your children were not worth you giving it up. Do you understand?
Yes, ma'am.
And stop having children until you get your life together.
Yes, ma'am.
All right, so he's going to retake IOP as well. Is there anything else you need from the court? And don't go into any more fights, especially if you don't know the name of the people.
Yes, ma'am.
And honestly, boxing hasn't been great since Sugar Ray Leonard and Muhammad Ali. People don't even have skills anymore.
Yes, ma'am.
So, all right, thank you.
Thank you.
Luis Gomez.
Another compliance hearing, Your Honor.
Come forward. Hello. Why are you missing your reporting dates to felony drug court?
Today was my first date.
Well, no, they said they attempted to contact you on April 10th, April 11th, April 14th. That's why you were rejected. You need felony drug court. If you're drug tested today, what are the results going to be? And before you even answer me, know that you can get drug tested today. I will have you drug tested today. I know sometimes people think the probation officer is female, so she can't do it. We have male probation officers in this building, and they will come right over and drug test you. So what are your results going to be? Did you use, let me help you. Did you use drugs?
I had in the past.
Do you want me to bring a probation officer over here to do a drug test? All right, so what are the results going to be? All right, what are you going to be positive for?
Meth,
All right, meth. And what else?
it's about it, marijuana.
Meth and marijuana. Probation, what are his issues other than these drug issues and his not appearing to felony drug court? Yes. And is it going to be heroin as well? Because last time you were here, it was heroin as well.
No.
Thank you.
Only been on probation a month at this point, so it really hasn't given enough time to complete the other terms of his probation. He did report no issues there. He's reporting, except for he was not putting in to report for his felony drug court.
All right, we're going to get a date for you today for felony drug court, Mr. Gomez. If you do not, if you miss that appointment, a motion to revoke is going to be filed. You understand?
Yes, ma'am.
So we're going to do it one more time. Do you have a telephone number?
Yes, ma'am. I've been getting the messages.
Well, why you not been reporting to them if you've been receiving messages?
Well, this was the date today.
All right. I think there's some drug cloudiness going on here. So, and I mean that in all sincerity. I'm not trying to belittle you or anything. I'm trying to save your life, because last time you were here was a heroin issue. Now it's a meth and marijuana issue. If you do not take care of these issues, what's going to end up happening is either you're going to end up in prison, or either somebody's going to find you on the street because you're going to get a bad batch of drugs. Do you understand?
Yes, ma'am.
All right, so let's do a re-referral to felony drug court. And if he misses his next appointment with felony drug court, a motion to revoke will be filed. All right, thank you. All right, just have a seat next to the person in the red shirt. Destiny Argumendo. Thank you. Where's your client?
She's actually in custody. She was out here and she had to go on the register.
Okay, all right, we'll wait for them to bring her out. Who's here on Jonathan Thomas?
PA and easy,
Yes.
compliance.
All right, come forward, Mr. Thomas. All right. Why are you missing your appointment with felony drug court?
Are those the people that come to my my house
No, those are the people that are calling you on the phone. Why are you missing your appointments with them?
for the drug test?
No, for felony drug court. I ordered you to be evaluated for felony drug court. Why are you missing that?
I don't need drug court. I have no clue.
Do you want to go to prison?
No, ma'am.
All right, if you're drug tested today, what are the results going to be? And know that I will have somebody come and drug test you.
Yes, ma'am.
What's the result?
Negative.
All right, we're gonna, Bashan, I'm gonna need a drug test for Mr. Thomas.
Yes, Your Honor.
And I'm gonna do a re-referral to felony drug court. If he misses that, then file a motion to revoke. And if he is positive for drugs, then we're gonna file a motion to revoke.
Yes.
All right, have a seat over there. Destiny Argumento, come forward. Court is calling 2022 CR 11474W, State of Texas versus Destiny Argumento. Could I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Cheryl Patterson with the defense.
All right. And are you Destiny Argumento?
And no, ma'am.
Well, Amanda
Yes,
Destiny Argumento. All right, I'm showing you what's entitled motion to revoke. I'm sorry.
Judge, really quickly, sorry to interrupt. Defense and I had spoken, I think defense had filed a motion for competency eval.
Mhm.
That's what we wanted to approach on.
Ah. So where are we on the competency?
I filed the motion. I don't know that anything has happened.
All right, when was the motion filed?
I believe it was early part of last week.
Oh, there.
Right.
Okay, thank you. All right, so it's been referred to magistrate's court. So, Ms. Ferguson, I need a reset on this. Can you let the magistrate know that she doesn't need an informal inquiry, that she just needs an evaluation?
Your Honor, we'd actually, in speaking with the prosecutor and with my client, we'd actually like to withdraw that motion. We feel that she just did not understand the questions and was very nervous that day.
Okay. All right, we're on the record then. Are you Amanda or Destiny Argumento?
Yes, ma'am.
Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Do you know who your attorney is?
Yes, ma'am.
Who is your attorney?
It's hard to pronounce her last name.
Okay, what's her first name?
Sorry.
Can you point to your attorney? Who's your attorney? All right. Have you had a chance to discuss her and discuss your case?
Yes, ma'am.
What are you on probation for?
Unauthorized use of vehicle.
All right. And who is the prosecutor in this case?
I am.
No, who is actually trying to prove that you violated the conditions of your probation?
Excuse me, I don't understand.
All right. How far did you go in school?
Ninth grade.
Okay. All right. You're on probation. Do you understand that?
Yes, ma'am.
Okay. You understand, you told me you're on probation for an unauthorized use of a vehicle?
Yes, ma'am.
What is your range of punishment?
It was 2 years of probation and parenting classes.
All right. If I were to send you to prison or to the state jail facility, how much time could I give you?
It was 2 years.
Okay. So with regards to this motion to revoke,
Yes, ma'am.
who has to prove to the court that you didn't do what you were supposed to do on a motion to revoke?
Myself.
I'm sorry?
Myself.
Okay. I think she may need an evaluation.
Yes, Your Honor.
Okay. All right. So this is going to be set for a evaluation. Ms. Ferguson, what date can we bring this back?
You can do June. I can do June 15th.
All right. So we're going to recall it back for June 15th.
Yes, Your
And
Honor.
Ms. Ferguson, if you will again, just let them know that there's no need for an informal inquiry. The court is requesting that the evaluation be done.
Okay.
All right. Thank you.
Thank you, Your Honor.
Thank you. All right, on Genevieve Pinter. Who's the attorney for Genevieve Pinter? All right, Pinter, come forward. Yes. Okay, thank you.
You know, on John Defer, nobody answered, so I sent him emails. And
Okay, just give me 1 second. I'm gonna call them so that I can get you a specific date.
thank you.
You're welcome. All right, so she's asking, thank you so much. All right, so there's a request for early termination on your case. I'm not inclined to give you early termination. I mean, what you did was awful. And there's a concern with you working with the elderly, which is what I put in here, that you're not allowed to have any work with vulnerable persons, any elderly people. So you want to be terminated early. Why should I do that?
Because, I mean, yes, I understand what I did was wrong. But I've never violated probation. I've never failed a drug test. I hold a steady job. And it's not even in the medical field anymore. I've been doing good. I know what I just want to put this past me and then just move forward with myself, better myself for my kids and myself.
Kids or baby goats? I wish people would stop
My
using.
children.
Thank you. I wish people would stop using the word kids for children. The complainant wants to move forward too, but you know why the complainant can't really move forward? They don't have their engagement ring. So where's their engagement ring?
I'm not sure.
Find their engagement ring, and then maybe I'll consider early termination.
It was, I don't know what they said, what happened with it, but I know it was. From my understanding, it was pawned in the pawn shop or something.
Well, I mean, this is an engagement ring that you're responsible for. So what do you mean? You're saying you're understanding that it was pawned in the pawn shop. You're acting like some phantom did that. Who pawned it in the pawn shop?
Myself.
All right, so where is their engagement ring? They want their engagement ring. You're before me saying you want your probation terminated early because you're ready to move on with your life. She wants her engagement ring. And since this is an elderly person, that means that engagement ring, they probably had it since who knows where, how long. And that engagement ring cost that person $15,000. And how much did you pawn it for?
I don't even remember. It's been a few years now.
Yeah. See, here's the thing. You commit a crime. And for you, it's like, oh, I'm done. I don't even remember.
No, it's not.
Yeah. I'm not giving you early termination. You're going to do every bit of the 8 years that you're on for this probation. And you need to sit and think about the engagement ring that you stole from an elderly person when they allowed you into their home to take care of them, and you went and pawned it. And you're walking around enjoying your best life, wearing eyelashes that are too long. I don't know why people are doing that. I think that's a new style or something, but no. So you are not going to be off of probation early. So probation, please tell probation officers to quit submitting me documentation asking for her to be taken off early. I'll only truly consider taking you off probation early if you return her $15,000 engagement ring that you took to some pawn shop and they probably gave you maybe $200 for it. She wants her engagement ring back, and you should want her to have it back. And then until you internalize what you did to her, an elderly person allowing you into their home to work and you stealing their engagement ring, you have learned nothing on probation. That's all. The answer is no.
Judge, may I approach you?
Yes.
You called my case. I was in the 227th. I've
Okay.
been waiting before, but I do have to do a plea in the
Who's your
227th.
client? Oh,
Mofness, just for a motion.
well, I'll
to
tell you
change
what,
the
if you
conduct order.
go ahead and do that, please, and then come back.
Thank you, Judge.
And we do have afternoon docket, so.
Thank you.
But that's not afternoon docket for everybody. That's afternoon docket because we have a jury trial. All right, Andy Maldonado. And then after that, I'm gonna take a short break to call. I'm gonna take a short break after that to call for felony drug court. All right, on this case, all right, there's discovery issues. What is the discovery issue?
So there's a cell phone download that there was a big mix up because the original detective on this case is no longer working in law enforcement and has charges against her now. And detective had to come in and kind of pick up the pieces, and there was a cell phone that he had to essentially get a new warrant for and resubmit. And he has talked, I spoke to him this morning, the tech guy, whoever it is at Kirby PD, says the cell phone will be ready on Monday.
All right, so what we're gonna do is I'm gonna reset this for the end of the month. Ms. Ferguson, can I have a date? All right, so we're gonna reset this for June 1st to make sure you have all the cell phone information.
Thank you, Judge.
Yes. And can you mute us, please? Because they're saying that they can screen him for next week.
Okay. Yes, Your Honor. He has a very supportive bunch of friends back there, and they will make sure, and I'll do the same.
All right, thank you. If you'll sign the reset form from Ms. Ferguson.
Yes, thank you, Your Honor.
Thank you.
Thank you, Your Honor.
You're welcome. Oscar Martinez.
Judge, I believe that was the one that we dealt with earlier, Deli. That's on the recall.
Yes. Okay, thank you. John, wait, did I do Casanova?
Council's President, Your Honor.
All right. All right, John Alberto Casanova Paez. All right, so today is his plea deadline date. What's happening?
Yes, Your Honor. First off, we'd like to thank the court for appointing immigration attorney to provide a Padilla letter. We did receive it. We now know the immigration consequences of the plea offer. We've received an offer and Mr. Casanova rejects this offer. We'd ask for a trial date. Daphne Previty is the lead attorney on the case, and she's given me dates in which she has vacation letters in for May 30th and June 27th. Other than those dates, she's
So,
available.
Ms. Ferguson, I'm gonna need a jury trial date on Casanova Paez. It's family violence. How long do y'all expect the trial to last?
3 or 4 days.
3 to 4 days.
I can do June 20th.
June 20th?
Yes, Your Honor, that'd be suitable. Thank you.
All right, so your jury trial date will be on June 20th. Your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Do you understand?
Yes.
All right, thank you.
Thank you,
You
Your
will
Honor.
be excused once you receive the plea. Once you sign the reset form. Armando Mata. Court is calling 2022 CR 10884, State of Texas versus Armando Mata. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense,
Alfonso Otero on behalf of Mr. Mata.
are you Armando Mata?
Yes, ma'am.
All right, have both parties received the PSI report, state?
Yes, Your Honor.
Defense,
Yes, Judge.
have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense,
Yes, Judge.
any objections to the PSI report, state?
No, Your Honor.
Defense,
Yes, Judge. There's a question, I don't remember the page, but whatever they asked Mr. Mata if he had a drug problem. The PSI reflects that he said not at all. I spoke to him about it. And what he understood at the time was that if he was doing drugs at the time, the PSI was. And so we request that that may be changed or corrected to reflect the Mr. Mata's true meaning of that answer. That
all right, that will be noted. Any witnesses from the state?
No, you are.
Any witnesses from the defense?
Yes, Judge. Oh, she went to the restroom.
And you have any witnesses?
Yes, Judge, but she's in the restroom.
Oh, okay. Is that your only witness?
Yes, Judge.
All right, then, as soon as your witness comes back, we'll continue.
Oh, thank you.
Sure.
Sorry about that.
Oh, no problem. Wayne Tolliver.
This is one that we agreed on an actual definitive time, Your Honor. It was established 6, but it's now
Fine.
Yes.
All right. Court is calling 2022 CR 10641, State of Texas versus Wayne Tolliver. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Jason Goss for Mr. Tolliver.
All right. So, are you Mr. Tolliver?
Yes, ma'am.
All right, you entered a plea of guilty on March 23rd. According to the plea bargaining agreement, the state and the defense both have now agreed to your punishment be assessed at 5 years in the prison, and there are no applications. Do you understand that to be the new plea bargaining agreement?
Yes, ma'am.
Are you asking the court to follow that agreement?
Yes, ma'am.
Defense state, is that the agreement?
It is, Your Honor.
Yes, sir.
And I believe there was a PSI that was tendered in this case. Have both parties had a chance to review the PSI?
Yes, Your Honor.
Yes, sir.
Any objections to the PSI, state or defense?
No, you're.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor, just that, as you can see from the PSI, my client has had his struggles with alcohol, but he did go to the penitentiary for the last time 20 years ago. And so he was sober for 20 years. He has been working in the same place for 40 years, almost 40 years, as a forklift operator. He has family here. He has his siblings here who support him. He has his wife that he has been with for the last 20 years, also here to support him. And we're just hoping that this will be the last relapse and the last time so that he can come out and provide for his family.
To go around.
Oh,
He needs to sign that.
this is just saying. Just saying. She don't have a right to what she calls them. So they're just asking for something. Thank you.
All right, and I'm sorry, Counselor, you were making remarks?
Yes, Your Honor, and just I guess to sum up that, he has lived a life well since the last time that he came out of prison, but he did have a relapse. The facts of this case were that he was asleep in his car that was in a parking garage. The car was on. We weren't contesting operation. That's why we have done the plea, because we've explained that to him. And he had a bad night. He had a bad moment, in 20 years of his life. And so he understands that he's got to pay for that, but we're just hoping that he can go and come out as soon as possible.
Okay. Is there a reason there's no recommendation for probation on this case?
Just from previous record, Your Honor.
All right. So, Mr. Tolliver, I'm going to give you an option. And it's because I'm reading the plea paperwork and I know you have a lot of DWIs. And I'm a firm believer that well, there are many things. In this case, there's no accident, you're asleep behind the wheel. You can either go to safety and be on probation. Safety is treatment. It's a long term of treatment. There's a waiting time. Or either I can sentence you to prison. Which would you prefer?
Your Honor, may I speak then briefly? Your Honor, he'll choose safety.
And I know state and according to the plea bargain agreement, you all were remaining silent.
Well, yeah.
So, well, in the original plea bargain agreement, you were silent, and then you all changed to 5 years prison.
Yes, sir.
So,
I believe.
well, no, actually,
It was a
it wasn't
cap
a
of-
silent, it was just I'm sorry,
Yeah,
it was
yeah.
just a cap of 6 years. So.
But our
state-
argument would be the same, Your Honor.
So do you have any objections, state, to the court making Mr. Tolliver the offer of going in inpatient treatment?
We will not oppose that.
All right, so you're gonna be taken into custody today. I'm gonna want him in inpatient treatment. And inpatient treatment at safety. If felony drug court determines they have an opening for him, because part of the reason is the felony drug court didn't accept him was because of the fact that they were at capacity. I know they're having a graduation coming up, so they won't be at capacity. And the other reason is they were saying that they think he may be in remission or whatever. But he can be re-referred to felony drug court, but he's going to remain in custody until either he's accepted in felony drug court or either he's going to safety.
Yes, Your Honor.
All right, so. And is there any objection to going back to the original plea bargain agreement, which was the cap of 6 opposed? I'm sorry, the cap of 6 with no application.
There is no objection to going back to that, obviously.
So the court is going to sentence you to 6 years in the prison, suspended and probated for 8 years. DWI intervention, DWI education, VIP live. There's to be no driving for the length of probation. Regular reporting by Zoom or in person. Regular UAs. 2-year driver's license suspension. He is to provide an affidavit of non-driving, but there's going to be ignition interlock on any vehicle that is, at your home, but you're not allowed to drive. And I'm going to want him on a portable device then. And I'm going to want field visits 1 time per month for 3 months upon release. And probation, if you feel there's no need after that, then you all can do it by randomly or however you feel is needed. I've already said a referral to felony drug court. I'm gonna order safe P. And he's to be remain in custody. Proof of employment. Within 30 days of release. There's to be no employment as a home health care provider with minors. And regular UAs. Is there anything else, probation?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, ma'am. Thank you.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're off the record. I take DWIs very seriously. People can get killed. But I do think that just sending someone to prison sometimes and then having them come out, they're gonna come out with the same issue. You need to stay hyper vigilant. You cannot drink alcohol at all. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you for the opportunity.
Thank you.
Can you make sure I did not put a separate docket sheet in there that shouldn't be alone in there? And everyone, the court is recessing at 1. Julio Sanchez. Okay, thank you. Court is calling 2019 CR 4665, State of Texas versus Julio Cesar Sanchez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Austin Hagy for Mr. Sanchez.
are you Mr. Julio Cesar Sanchez?
Yes, Your Honor.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Julio Cesar Sanchez who was placed on deferred adjudication in 2019 CR 4665 for the offense of unlawfully carrying a weapon on prohibited premises on October 3rd, 2019 for a period of 4 years? Is that you?
Yes, ma'am.
State?
Violated condition number 15 on or about the 22nd day of June 2022 in Bexar County, Texas. The defendant Julio Cesar Sanchez did then and there fail to comply with the instructions of Bexar County CSCD Intensive Outpatient Treatment Program directed by the head or authorized personnel of that agency. In that the defendant failed to submit urinalysis on May 30th, 2022, June 9th, 2022, June 15th, 2022, and failed to attend group individualized Zoom sessions in violation of condition number 15.
How do you plead to that? True or not true?
True.
State?
Your Honor, state waives all the violations.
Any objections?
No objection.
To understand by pleading true to violation of condition number 15, the court can find it true, grant the motion, sentence you to 10 years in prison and up to a $10,000 fine. Knowing that, do you still wish to plead true to violation of condition number 15?
Yes, ma'am.
Court will find violation of 15 true. Is there an agreement?
Yes, Your Honor, there is. It's agreed revocation for 2 years in TDC.
Right. Is that the agreement?
Yes, Your Honor, that's the agreement.
All right. Are you asking the court to follow that agreement? Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will follow your agreement, find you guilty, grant the motion, sentence you to 2 years in the prison, give you credit for any time served. And there's $1,000 fine. Time and money will run concurrent. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. You're gonna have to change your way. You understand? All right, good luck.
Thank you.
You're welcome. Who is here on Michael Green. All right, Mr. Green. All right, Mr. Green, here's the issue. Felony drug court will not accept you because of the gang affiliation issues. So, that's the report I have. So we need to figure out another place to send you. So probation, what do you suggest?
Your Honor, the last time we were here. Give me 1 second, I'm sorry. The last time we were here, we were going to do state ISF.
All right, so they're gonna take you to state ISF because felony drug court will not accept you. You understand?
Yes, ma'am.
All right. Yes,
Say something.
yes, of course.
Okay, they stated I was a gang member. I mean, I gang banged back in the day. I went through TDC program and got a certificate on everything at the Walls unit for me to be excluded. You know, I know if they type my name in, it's still gonna show up in the computer.
But you were actually in the program?
Yes, ma'am, I was.
All right, this is what we're gonna do. Ms. Abrams, can you send a message to felony drug court, letting him know that he was in a program at the prison to, what's the name of the program?
It was, I think it was tap or something like that. And I got my gang tattoos covered up,
All right,
all of them.
so can you, we're gonna refer you back to felony drug court. And Ms. Abrams gonna send a note to them that you no longer have your gang tattoos, they've been covered up. And that you did a program at the prison, and we're gonna see if they accept you, okay?
Yes, ma'am.
All right, so let's do that and see if they can put him on their docket for next week. And then if they don't accept him, we'll come back here in 2 weeks. All right, thank you.
Thank you.
You're welcome.
Morning, Judge.
Good morning.
Judge and Mr. Mata, my witness is back.
All right,
Whenever the court's ready.
okay, just give me 1 moment.
Yes, sir.
Matthew Santos. Court is calling 2022 CR 4013, State of Texas versus Matthew Raleigh Santos. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Abelardo Garza.
are you Mr. Santos?
Yes, ma'am.
I'm going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Matthew Ray Santos who was placed on deferred adjudication for the offense of burglary of a building with intent to commit theft on August 1st, 2022 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant Matthew Ray Santos did then and there fail to report to the supervision officer as director for the months of January and February 2023 in violation of condition 4.
How do you plead to that? True or not true? State.
State waives all the violations.
Any objections to the state's waivers?
No objections, Your
You
Honor.
understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there an agreement?
There is, Your Honor. It's to alter and amend to include Bexar ISF.
Is that the agreement?
That's the agreement, Your Honor.
All right, the court will deny the motion, alter and amend conditions to include ISF.
Yes, ma'am.
All right, Mr. Santos, what is your issue? Why are you not reporting?
Your Honor, if I may,
Yes.
while he's there, maybe he needs to get some mental help. His mother recently passed away a few months ago.
All right, probation, can you have him evaluated for Mick? All right, is there anything else that you need, Mr. Santos?
No.
All right, we can go off the record. Mr. Santos, in this court, in order to be successful on probation, the court encourages people to communicate. Communicate with probation if there's an issue. You just can't disappear and fall off the planet, okay?
Sorry, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Have the excuse. Right?
Yes. All right, Mata. All right, we're back on the record in 2022 CR 10884. And defense, you were calling a witness.
Yes, Judge, defense called Elizabeth Mata.
All right, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. I'm gonna need you to speak up.
Okay.
All right, state your name for the record.
Elizabeth Mata.
All right.
Defense. Thank you, Judge. Ms. Mata, what's your relationship with Mr. Mata?
He's my son.
And currently, where is he living at?
He's living with me.
And are you aware that he may have a drug addiction problem? And when did you learn about his drug addiction problem?
His whole addiction problem started in around 2009 when he was involved in a motorcycle accident. He broke his knee and his hip, and he was prescribed what's it called, morphine in the hospital. And then when he was released, he was prescribed oxycodone, and that's when all his problems started.
Okay, and but after using those medically prescribed medication, he started doing illegal drugs.
Harder drugs, yes.
And who lives there with you and him?
Just me and him.
Okay, and where you live at?
We live in Dorito.
Does he have a job right now?
He's actively looking for a job, but he's got one job already lined up, but he wanted to get this started.
Okay, do you think he may benefit from drug treatment?
Yes.
Has he ever been in drug treatment? Do you know? Yes, and when?
I don't remember the years, but he's had like two stints and we have. But of course, if you don't have insurance, unless you're court ordered, it's not, they're not gonna keep you there.
Okay. And if he's granted probation, would you be willing to help him do anything he's got to do to complete those?
Of course. Mhm.
No more questions, Judge.
Any questions?
No question, Judge.
All right, thank you so much for coming in. Defense, any more witnesses?
No, Judge.
All right, then the court, the state is silent. The court will hear argument.
Yes, Judge, the defendant, we acknowledge that he has a long criminal history. He has a long history of criminal arrests. Only one felony conviction we can see in the PSI, has a couple of misdemeanor convictions. He does not show any propensity to violence. Reading the history of the defendant, we can assume that he has a addiction problem to drugs. He has been on parole for a while. His parole officer has also recommended that he be on probation. They think that that may be beneficial to him. He has complied with parole, I'm sorry. Besides picking up these cases, Judge. I spoke to him about what has motivated him to do this, and what he's telling me is that he is a heavy user of meth and heroin. Those two things are very dangerous on people, very addictive. Very hard to break those addictions. He's willing to change his life, move on, finish his education, and turn his life around. I've talked to him about it, to what would he would be willing to do in order to accomplish those things, and he is agreeable to do any treatment that the court may order him to do. Other than that, Judge, I think he's got a heavy problem about drug usage, and he could benefit from maybe failing the drug court if he's eligible for it, or any type of probation, including treatment. Other than that, Judge, we will ask the court to grant probation.
All right, Mr. Mata, I've looked at your criminal history. I just don't go by criminal history. I go by other things as well. I've listened to your mother testify. And also, I always review again the stipulations. And you had a large amount of drugs. You understand?
Yes, ma'am.
So the court is going to deny your application. The court will find you guilty, taking consideration 2022 CR 10885, county court cause number 692603, 692604, 692605. Court will sentence you to 5 years in the prison. Give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of a weapon or ammunition, need to speak to an attorney. Do you understand?
Mm-hmm.
All right, if you have a problem with a drug or alcohol issue, I can ask that you be referred to the therapeutic community. The therapeutic community does not increase the length of time that you're in custody, but I can't force them to place you in it. But if you request it, they can consider it and they'll see that I recommended it. Do you have any objections to that?
Mm-hmm.
All right, I'm sorry, Caroline, could you put in that therapeutic community? All right, thank you. Thank you.
Thank you, Judge, maybe excuse.
Yes, who's here on Nicholas Ornelas?
I am, Your Honor, Mr. Ornelas, present, Judge.
All right. Mr. Ornelas, come forward. Court is calling 2015 CR 6277 and 2014 CR 0519, State of Texas versus Nicholas Ornelas. Could I have parties announced for the record for the state?
Lindsay Shaw for the state.
Defense.
Roberto May, on behalf of Mr. Ornelas, Mr. Ornelas, present, Your Honor, on bond, ready.
Are you Mr. Ornelas?
Yes, ma'am.
And each of the cause numbers, I'm going to show you what's entitled motion to revoke community supervision and first amended motion to revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Nicholas Ornelas who was placed on community supervision in 2014 CR 0519 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on June 11, 2018 for a term of 7 years? Is that you?
Yes, ma'am.
And are you the same Nicholas Ornelas who was placed on community supervision in 2015 CR 6277 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on June 11, 2018 for a term of 7 years? Is that you?
No.
Right. State, are you proceeding on the same allegation in each motion?
Yes, ma'am.
Defense, do you have any objection to the state reading the allegation once and then your client entering pleas to the allegation in each motion?
No allegation. I mean, no objection.
All right, state.
Judge, the state will proceed on the motion to revoke on the most recent violated condition number 2, which reads on or about the 6th day of January 2023 in Bexar County, Texas. The defendant Nicholas Ornelas did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that, true or not true?
We'll waive all the remaining violations, Judge.
Any objections to the waivers?
None, Your Honor.
All right, did you understand by pleading true to violation number 2 in 2014 CR 0159, the court could find it true, grant the motion, and sentence you up to 4 years in prison and up to a $1,500 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 in that cause number 2015 CR 6277. Did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, and sentence you up to 7 years in prison? Did you understand? Knowing that, do you still wish to plead true to violation of condition number 2 in that cause number?
Yes.
Then in that cause number, the court will find violation of condition number 2 true. Is there an agreement?
Yes, ma'am, there is. Subject to court's approval, the agreement is that the court deny the MTR, conditions be altered and amended for him to complete SACs.
All right, is that the agreement?
That is the agreement, Your Honor.
Are you asking the court to follow that agreement? All right, the court will deny the motion in each cause number. Alter and amend conditions to include SATA. Defendant will be taken into custody today, and he's to remain in custody until transferred to SATA.
Your Honor, we did discuss it with the state, and I would ask the court to consider allowing him to surrender next Monday.
That will be denied.
Thank you, Judge, for your consideration.
Thank you, you're welcome. Good luck to you.
Excuse, Judge.
Yes, you may be
Thank you.
excused.
Yeah, no, they're here.
Hillary Stillman.
Compliance hearing.
All right, Mr. Stillman. See, communication is key.
Gorilla in Manila,
Yeah, there you go.
floats like a
Yes.
butterfly and stings like a bee, man.
There you go.
Little Mike Tyson was amusing sometimes.
Yeah. All right, so what is his TAP evaluation? It is for safety, correct?
Your Honor,
That's what I have.
just give me one moment.
Sure.
I have the direct report outcome.
Ah, yes, I see it. So he'll be going to safety. So that's where you'll be headed.
Okay, and what is the time limit on waiting?
That's a drug treatment facility.
Not for course, but waiting to get there.
I don't know, what is the wait time?
For safety, Your Honor. It would be about a month.
That's the wait time.
All right, thank you.
All right, thank you.
Yes, ma'am.
That's what we have then, safety. Did you want something else, probation?
No, Your Honor.
You sure? I saw what it said from the felony drug court.
Yes, Your Honor.
All right, Jesse Rabago. And then after that, it will be the patiently waiting Linda Conley.
Thank you.
And then after that, it's going to be Villamil, then we're taking our lunch. All right, Jesse Rabago.
Yes, ma'am.
All right, so what is happening with this case?
Your Honor, I just got appointed on this on 9 days ago, Your Honor. I haven't had time to look at the discovery, Your Honor. I'd like to get a reset on it. Dr. Mr. Vago explained it to him. He also has a pre-indictment that's coming up. It hasn't been,
What is the pre-indicted case?
it's a continuous family.
All right, do you have are you the attorney on that? case?
I just got appointed on that one also.
All right, Ms. First, can I have a 30-day reset on Rabago?
Yes, ma'am. I can do June 5th.
All right, we're gonna come back on June 5th. State on June 5th, you'll need to make an offer on Rabago. He has a felon in possession of the weapon and continuous family violence. All right, thank you. Thank you.
Just have a seat, sir.
Jess Moffness. I believe this is your case, Ms. Corley.
Yes, Judge. This is a motion to change no contact order into a no harmful or injurious contact order. We do have the complainant here, Judge. It is his stepfather, and he is in the courtroom. And I believe we have no objections from the state.
I'm sorry, what?
We had no objections from the state.
All right. All right, and this is, I believe the state is requesting he be allowed to do a PTD, is that correct?
Yes,
All right, it's coming back on June 1st.
yes, Your Honor.
All right, and we're gonna go on the record. Court is calling 2023 CR 1477, State of Texas versus Jess Loch Ness. And I believe this is family violence, isn't it?
It is.
Oh, yes. All right, defense filed a motion to amend bond conditions. They're asking that the motion be changed from no contact to no harmful or injurious contact.
We didn't have any objections when I talked to the complainant yesterday on Monday, but I do have him here.
Oh, where's the complainant? This is something.
He's in the courtroom.
Okay. All right, do you wish to speak to the complainant, State?
Yes.
Okay.
All right, and just for the record, I don't know his name, the prosecutor that was sent it.
Yeah, we're off the record.
Oh.
Yeah, he talked to him on Monday in detail,
Oh, we did.
and he
Okay.
said he didn't have any objections. But I mean, he's here.
Brittany, you can go ahead and
Yeah,
speak with them.
Let
All right.
me, let me.
So
consider-
just step back for a
Thanks,
moment.
Judge.
That'll probably make things go quicker. Who's here on Villa Mill? All right, come forward. So we have all the discovery?
I believe we do. There's still some investigation that we are doing, but I believe we have all the discovery we need from the state.
Okay. All right, Ms. Ferguson, can I have a 30-day reset? All right, we're gonna come back on June 5th. On June 5th, the state is gonna make an offer, then there'll be a quick turnaround for a plea deadline date.
Yes, Your Honor. Understood. May we be excused?
Yes, well, not your client.
Well, no.
Yeah, okay,
Uh,
but you may be excused. Thank
Thank
you.
Yeah.
How do you spell the last name on Linda's?
It is Takai. Do you want her motion? Yeah. And then after this, we'll go to lunch and we'll start trial back up we're gonna start trial up at 2:30. Okay, where is the crowd gone? It was extremely crowded in court today. So that's a sign we have done cases, I believe. And then I think I've seen everybody in the box. So great.
Oh, Mr. Green, I'm gonna talk to you.
Yes, Mr. Green? Yes.
This judge, Michael Green.
Yes.
Oh, okay, okay, I'm familiar.
I'll come down, sir. Yes, I received a note from probation saying you wanted to speak to me.
Yes, ma'am.
Yes.
When I went over there to drug court, I think her name Vanessa Spears, gave me this card and put this lifetime recovery.
Okay.
She told me to give it to my lawyer, but I don't know where my lawyer.
No, I understand. So here's the thing. You don't have an attorney right now because this is just a compliance hearing. It's for me to understand what's going on with you.
Yes.
And the reason why compliance hearings are not on the record, because I don't hold it against the people who are before me. It's just me getting with probation so I can understand what's going on. So probation?
Your Honor, we wouldn't be opposed to lifetime recovery inpatient.
Okay, all right. So would you like to do lifetime recovery inpatient instead of being referred back to felony drug court?
Yeah, any one of them that'll help me. You know, I ain't being picky on neither one of them.
Oh, I appreciate that. All right, so whichever one is the quickest.
Okay.
And then, but I really want the record to be clear with felony drug court that he went through all the steps to remove himself from any gang affiliation.
Yes, Your Honor.
All right.
Yes, ma'am.
All right, thank you for letting me know. I appreciate that.
Yes, ma'am.
Okay, yes, I am familiar with this case.
All right, so we're back on the record in 2023 CR 1477, State of Texas versus Jess Moffness. Oh, yeah. All right, State, have you had a chance to review the bond
Yes,
application?
yes, Your Honor, we don't have an objection to it.
Judge, we would just request it be a no harmful or injurious.
All right, could I see Juan? Okay,
It's Takai.
Takai, have you come forward, Mr. Takai? Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Could you state your name for the record
My name is Juan L. Takai.
and how you spell the last name?
T as in Texas.
Oh, no, don't do just spell it.
Takai.
All right, and I asked you to do that because court reporters don't like when you say T is in Texas, A is in this. It makes it more difficult for them. So what is your relationship to Mr. Jess Mockness?
This is my stepson.
All right, so defense counsel is here asking that the no contact order be lifted and that it be a no harmful or injurious contact order. Do you understand what that means?
Yes, ma'am.
All right, are you in agreement with that?
Yes, ma'am.
Do you have any fear of Mr. Mockness?
No, ma'am.
All right, any questions from state or defense?
No, Your Honor.
None, Judge.
All right, thank you so much.
You're welcome, ma'am.
And I just have a few questions for your client. It's unrelated to the facts of the case. All right, can you raise your right hand for me? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Just Moffness.
All right, so Mr. Mockness, where are you staying? And when I say where you're staying, you're not living at this point in time with Mr. Takai.
No, ma'am.
All right, so are you staying with someone else?
With my mom.
Okay, and is Mr. Takai out of the residence or how's that working?
Well, Judge, let me just, for the court, they were all three living together. And so his stepdad went ahead and left because of the no contact order, and he's still with his mom. He's currently in search of a job. He's had some problems because of the criminal history, but he is currently in search of a job. And so if you grant the no harmful order, then the plan is for his stepdad to move back in with him as well.
All right, so Mr. Mockness, I don't take any of this as true because facts haven't presented to me that the alleged offense is true or not true, okay?
Yes.
But I need to have some sort of insurance that tempers don't flare up and we're not back here for something else. So has your client been working on himself? What's been going on?
Judge, he hasn't had any problems. He has been with his mom and they've had no problems going on. I can tell you that when I could have asked his stepdad this, I didn't think about it, but nothing like this has ever happened with them before. It was an anomaly. He's never had that problem before. They were shocked that this even happened, is what he told me. And so we're not expecting it to be a problem again because it hadn't been a problem in the past.
All right, well, I'll go ahead and go with your agreement and I'll note for the record that the state has requested that he be considered for pretrial diversion. And I will grant the motion, and Mr. Takai knows that one, he hasn't been living at the home, so he doesn't necessarily have to live at the home if he doesn't want to live at the home. So I'll grant the motion. And we'll be
Thank you,
back on
Judge.
June 1st.
Thank you, Judge.
All right, thank you.
And just to be clear, we haven't given any approval. We've simply sent a summary to those who make that decision.
Okay.
Yes.
Thank you. All right, so with that being said, we'll be back here at 2:30 for jury trial.